Hello, everyone, and welcome to One Civil Law. I hope you're having a great day. For today's case, we turn our attention to the sentencing of Ashley Benefield in Florida. Much like Sarah Boone, a woman has been convicted of second-degree murder in Florida, this time facing a maximum of 30 years. I forget the reason for the difference. Sarah Boone was facing, of course, life and got life. Ashley Benefield is not facing life. She's facing a maximum of 30 years. But both women were convicted of second-degree murder in Florida in what they claimed was a self-defense situation. Both women claimed that they were the victims of domestic abuse and domestic violence. And in both cases, they said that they killed their significant other in order to protect themselves. And in both cases, the jury convicted. And one of the things I think that's really interesting is watching people's reactions to this versus Sarah Boone. Now, there are some pretty material differences between this case and Sarah Boone. With Sarah Boone, we actually have video, essentially, of the murder because she videotaped the suitcase with her mocking and all the rest of it. Whereas we don't have any video or any other objective evidence of the situation that befell Ashley Benefield. She is the only witness to this. There is no other evidence that really is available as to what happened in the moment of truth, right? There's evidence that relates to their relationship. There's evidence that relates to whether or not she's a victim of domestic violence. But there's really no evidence beyond her word as to what happened in that room. So just for, way of background, because some of you may not be familiar with the case, I'll give you a very brief rundown of the case. So Ashley Benefield says, and the evidence supports, that she was a victim of domestic violence, the degree to which, of course, is open to some interpretation. She says that she invited him over to her house to help pack. And then she says that he refused to allow her to leave, was being abusive to her, was being controlling, being threatening to her. She says she ultimately feared for her life and she tried to retreat. She retreated into the bedroom. She says he followed her, into the bedroom, and she ultimately shot him in self-defense due to an imminent threat. The jury did not ultimately believe this because they convicted her. They convicted her of second-degree murder. They believed that there was proof beyond a reasonable doubt that this story is fundamentally not true. And this ultimately comes down to your belief in Ashley Benefield as to the moment of truth, right? Because there's really no other evidence as to what's true in the moment of truth. And I did not believe Ashley Benefield. I found her to be a liar. I found her to be not credible. I found her to be exaggerating. I found her to be a witness that did not strike me as credible. And so because, it's basically a one-witness case, and she was unable to ultimately convince me, and I believe that she is guilty. Now, what's really interesting, I think, about this versus Sarah Boone is the reaction of people. Because basically no one believes Sarah Boone, right? No one believes Sarah Boone, or if there are, I haven't met them. So no one has a problem with mocking Sarah Boone. Like, oh, you say you're a victim of domestic violence, Sarah Boone. You say that you're a victim. And again, even with Sarah Boone, there is some evidence to suggest there was an abusive relationship between them, including, for example, stab marks. Now, you might think that those were self-inflicted. You might think that, again, it's exaggeration. You might think she's the instigator. But there is some evidence to support the proposition that there was domestic discord between Sarah Boone and her paramour. But no one seems to have a problem mocking Sarah Boone because ultimately we all seem to have come to the conclusion that we don't believe her. We don't believe her. She's not really a victim of domestic violence. She's more the perpetrator of domestic violence. And, she just can't say, I'm a victim of domestic violence. And we're all like, oh, okay. Okay. We believe you. But with respect to Ashley Benefield, for example, I've been equally mocking of Ashley, or at least comparatively mocking of Ashley, because I don't believe her. But a lot of people do believe her, so they find my mocking of Ashley to be morally reprehensible. And I just think that's an interesting thing, because it's like, well, you had no problem mocking Sarah Boone as a supposed victim of domestic violence, because obviously you don't believe her. You don't believe her, or you don't think it matters, or you think that she's just a cruel, heartless woman. So you have no problem mocking her, despite the fact, but my victimhood, though, right? So you have no problem mocking Sarah Boone, but you do have a problem, or at least there seems to be a problem, with me mocking Ashley Benefield, even though I'm only mocking her because I don't believe her. I'm ultimately mocking her because I find her story to be non-credible in the literal sense. It is literally incredible. And the jury thought so too. So the jury and I are of a common opinion. And so that's that. So I just think it's interesting. And I just want to state this for the record, by the way. I did not go into Melanie Little's chat, and I hope she knows this. And if she doesn't, I'll try telling her at some later point. But I didn't go into Melanie Little's chat for the purpose of like trying to start shit. That wasn't my objective. Okay. My objective was simply to try to participate in chat and provide my perspective. Now, it is true that in the case of Ashley Benefield, my perspective seems to be in the minority. I asked the moderators in her chat today, and I asked them for the purpose of trying to gauge, the sort of divide within her chat, because I'm not trying to start shit. So I asked her, or I didn't ask her, I asked her moderators, roughly speaking, what do you think is the percentage of people that support Ashley and think the jury got it wrong? And one of her mods was kind enough to say, 85%. So I was like, okay, because I knew from last time that, I was definitely in the minority, but I was interested in the third party perspective as to, how much a minority that was. Because I'm not really here for the purpose of starting shit. That's not really what I'm trying to do. Or at least not on someone else's channel. I'm not really trying to like start things within their channel. I'm not trying to be a chaotic agent within their channel. They have every right to their channel and their community, and I'm not trying to interfere with that. I'm not trying to like make Melanie's life worse. I like Melanie on a personal level. I'm not sure how she feels about me on a personal level. I know that she does not see eye to eye with me on this case. I'm not sure the degree to which that influences her overall opinion of me, but she can speak to that. But we just disagree, which is fine, at least as far as I'm concerned. But yeah, I went into Melanie Little's chat like during the guilt phase, and I'm like, oh, I don't believe it. And I was mocking her, and her chat was not really having it because her chat overwhelmingly supports Ashley. They think that, that Ashley is a victim of domestic violence, and they think, generally speaking, the jury got it wrong, as reflected by their moderator, who thinks it's about 85-15, which seems probably plausible. So, Melanie, said, I should probably not be there today, and I understand that, and I respect that. So I just went on my own channel, and I'll just share my own thoughts here. And, that's fine. And we can just have a difference of opinion, and hopefully we can continue being friends, Melanie and me. That would be nice. I'm not out here to mock victims of domestic violence. But of course, that presupposes the very thing we're trying to establish, which is part of the problem, right? We're trying to determine in fact what is true, because it's a trial, right? And we learned, at least from Sarah Boone, that we simply can't take the woman's word for it. It's not simply enough to say, oh, I'm a victim. We recognize that Sarah Boone is lying or grossly exaggerating, or has been the perpetrator herself. So, but I'm a victim, though. Like, no one believes Sarah Boone, so no one has a problem mocking her, right? So I'm not out to mock a victim of domestic violence, but that presupposes the very thing that, we're trying to establish, which is whether or not Ashley Benefield is a victim of domestic violence, or perhaps even more to the point, whether or not she was a victim of domestic violence in the moment in question. Because even if you believe Ashley Benefield was a victim of domestic violence up to the day in question, even if you believe everything she has to say about whether or not she was a victim or not, even if you believe every word that comes out of her mouth, ultimately, of course, when it comes to self-defense, what matters is what happens, what's true in the moment, right? So what happened, what matters is what's true when that trigger is pulled. That's what matters. We're trying to determine, of course, as always, whether or not there was an imminent threat of death or grievous bodily harm to Ashley Benefield, and whether or not, therefore, her response was warranted as a matter of law. And ultimately, it comes down to whether or not you believe Ashley Benefield about what happened in that house and what happened in that room. And incidentally, by the way, there is some objective evidence to suggest against. Namely, for example, that one of the shots seems to have come into the back. Now, she says it's because he was lunging at her, right? He was lunging at her, so the bullet went into his back. But I don't know, man. I don't buy it, right? So I think he was trying to flee, and she shot him. Not out of imminent fear, but out of a mistaken perception. And so I'm not out to mock victims of domestic violence. That is really not my objective. I am out to call bullshit on people who are not victims of domestic violence or are using claims of domestic violence as a illegitimate shield against legal culpability. I am out to mock people who use domestic violence or being a victim as a shield for their own illegal behavior, because they are misusing their status to try to give themselves a buy. And that, I think, is worthy of mockery. But of course, that presupposes, or not presupposes rather, that is contingent on whether or not you believe Ashley Benefield. If you believe Ashley Benefield, then you probably believe I'm a horrible monster for mocking her. And if you don't believe Ashley Benefield, then you think that, much like Sarah Boone, she's worthy of mockery because she's, ultimately a bad person. Ultimately, even though maybe she was a victim of domestic violence, ultimately, in the end, she pulled the trigger when she wasn't supposed to, and she's a murderer. And if it's not okay to mock a murderer, I don't know what we're doing here. If it's not okay to mock a murderer, I don't know what we're doing here. Okay? So I don't know what to say beyond that. So, if you believe Ashley Benefield, if you believe that, he was being abusive that day, if you believe she ran into the room in order to flee, as opposed to trying to get to the weapon for the sake of getting to the weapon, for malicious reasons, if you believe that he lunged at her, if you believe that, he was all those things, then I guess, and it is proof beyond a reasonable doubt, so you do have that going for you. The state does have to disprove it beyond a reasonable doubt. So if you believe Ashley, or if you believe there's reasonable doubt for Ashley, okay, I guess. I just don't see it that way. Neither does the jury. We appear to be of the collective opinion that Ashley Benefield is a liar who is trying to cloak herself in the flag of victimhood. And I didn't go in there to poke the bear. That was not my objective. That was not what I was trying to do. That was the unintentional effect of what happened, but it wasn't my motive. So to the extent you care about my motives, that wasn't my motive. And maybe motive isn't important to you, but that wasn't my motive. My motive wasn't to poke the bear. My motive was simply to participate in chat and share my opinion, which was the minority opinion. But I wasn't sharing my minority opinion for the purpose of riling up the majority. I was sharing my minority opinion because it was my minority opinion. I wasn't trying to start shit. I don't disrespect Melanie. I like her. I hope she likes me. I know we don't see eye to eye on this case. I know that she thinks, well, I honestly don't know what she ultimately thinks about it. I do know she thinks that Ashley Benefield was the victim of domestic violence, and I think that she finds my mockery of her to be inappropriate, but I'm not necessarily mocking her because she's a victim of domestic violence. It's not why I'm mocking her. I'm mocking her because she's a lying murderer who may or may not happen to be a victim of domestic violence, but the fact that she is or is not a victim of domestic violence is kind of irrelevant if you come to the conclusion she's a lying murderer. Because you're not allowed to murder people just because you're a victim of domestic violence. That's not a free pass. So whether or not she's a victim of domestic violence is kind of irrelevant, at least as the liability. As to liability, it's irrelevant. Now, it may be relevant as to sentencing. It may be relevant as to sentencing because it could be potentially a mitigating factor. So it's relevant potentially today, but it wasn't relevant when we were doing guilt. But it may be relevant today. So, you know, we'll assess that. Although, to be fair, on the other hand, because the jury found guilt, we can infer any fact that would support that conclusion and discount any fact that would oppose that conclusion. Because the jury found guilt, she is no longer presumed innocent. She is, in fact, guilty. Innocent till proven guilty is over now. It is no longer innocent till proven guilty. She is, in fact, guilty. A jury said so. And so, and as a result of that, we can infer the jury found any fact that would be helpful towards that conclusion and discounted any fact that would be dishelpful to that conclusion. We can skew all the evidence in favor of the verdict because there's a verdict now. Just as the same way, like before we skewed it the other way, but now that there's a conviction, we skew it in favor of the verdict. We skew it in favor of guilty. So, yeah. Yeah. I hope this chat isn't this chat shouldn't be turning into criticizing how another creator manages their channel. That is not my objective. That is not my objective. I'm not trying to criticize Melanie for running her channel. She can run her channel any way that she sees fit. And if she feels like I'm being disruptive, she has every right to ask me to leave. You know, that's her prerogative. I ask people to leave my chat all the time because I think they're being disruptive. But it wasn't my objective to be disruptive, and I'm not criticizing Melanie for the way that she runs the chat. I like Melanie on a personal level. I think she's fundamentally a good person, from what I can tell. She doesn't see eye to eye with me on this case. That's okay. Hopefully that doesn't broadly impact her perception of me on a personal level. That would be nice. You know, I think we see eye to eye, for example, in the Sarah Boone case. We both mock this victim of domestic violence because we both either, one, don't believe she is a victim of domestic violence, or two, believe she's a lying murderer, so it doesn't matter in the end either way. So, yeah, but we're not trying to criticize Melanie for the way she runs her channel. That is not my objective here. I'm just simply trying to explain my own motives. I'm trying to explain the reasons that I was doing certain things. I was simply there because I was expressing my genuine opinion. I wasn't there for the purpose of riling up. I'm not trying to make Melanie mad. I'm not trying to rile up her chat. I have nothing against her chat. I have nothing against Melanie. Her chat and I don't see eye to eye. According to one of their moderators, at least 85% of her chat disagrees with me. 85% of her chat thinks, broadly speaking, you know, and it's just a, you know, kind of off the cuff number. It's not a real number, but, you know, 85% of her chat, you know, broadly speaking, thinks that supports Ashley and believes the jury got it wrong. So I'm well in the minority, but I'm not trying to cause shit. Longtime supporter here, but you did come off as you're trying to gloat against the chatters. And Boone and Benefield couldn't be more different. Well, I don't know the degree to which they couldn't be more different. I don't know that I necessarily agree with that. They're comparable in some ways, and they're not comparable in some ways. But they're both women who have made claims of domestic violence, and they're both women who say domestic violence caused them to fear and have, you know, the responses they did, and both try to use domestic violence as a shield for their respective crimes. So now, Boone is just an out-and-out sadistic narcissist, but from a legal frame, they're not that different. You know, Sarah Boone is fundamentally perhaps a worse person than Ashley Benefield. But like from a legal frame, their legal frame is at least superficially comparable. So I don't know about that, but yeah. How do I know for certain they used it as a shield? Well, they were trying to use it as a shield in both cases. And how do I know for a fact they did use it as a shield? Because I watched the testimony and I disbelieved her testimony. The same way the jury did. The same way the jury did. The jury and I both watched her testimony and both found her testimony to not be credible. And so therefore the conclusion is that she was using it as a false shield. You know, the same way the jury did. You, the members of the jury, have the power to determine whether or not any witness is credible or not, and the degree to which they're credible. And if you believe a witness in whole or part, you can disbelieve a witness in part, you can disbelieve parts of their testimony, you can disbelieve all their testimony. It's up to you. Credibility is a question for the jury. So, you know, nothing up my sleeve the same way the jury did. Do I believe Doug Benefield to be a good man? I don't know. I don't know. To me, it doesn't really matter. From a legal frame, it doesn't really matter. Because, again, like domestic violence doesn't give you a shield in the end. It doesn't give you a get out of murder free pass. So my belief about Doug Benefield doesn't really matter. What really matters in the end is, well, it's a self-defense claim. So what really matters in the end? Right? What really matters in the end? Well, what really matters in the end is, was there an imminent threat of death or grievous bodily harm that was posed to Ashley Benefield, to which she was not the initiator? Right? That's like the ultimate legal question. And nothing else, everything else kind of disappears in the end. You know? You burn away the irrelevancies until you're left with the truth. And so was Doug Benefield a good person? I don't know. Do I believe that he was posing an imminent threat of death or grievous bodily harm? I do not. On what basis do I draw that conclusion? Her testimony, I didn't find it credible. You know. So, yeah. But I like Melanie Little. I like Melanie Little as a person. I like her channel. I'm not trying to start shit with her channel. I like her. I hope she understands that I wasn't trying to start shit. That isn't my motive. When she asked me to leave, I did, because I'm not trying to start shit. You know? But yeah. All right. Well, that's enough prelude. I have enough prelude. But yeah, Melanie can run her channel any way she sees fit. And the fact that her chat doesn't see it the same way I do, then, you know, we just don't see eye to eye. But, you know, yeah. And I'm not mocking Ashley Benefield because she's a victim of domestic violence. I'm mocking her because she's a lying murderer. And I draw that conclusion based on her testimony, to which I did not find credible. And I'm allowed to assess her credibility just the same way the jury is. Nothing up my sleeve. Thank you, Carolina Moon, for the 10 super chats. Yeah. Yes, I like Melanie Little. I'm just going out of my way to some degree to clarify this point, because I don't want there to be misunderstanding. So I have to be very, very clear. So I'm sorry for being repetitive, but I don't want to be misunderstood. So. How many times am I going to say take it up with Melanie later? As many times as I need to. That's how many times. Oh, yes. And Melanie Little also has been under quite a lot of stress on a personal level because she's been attacked personally for her opinions on Karen Read. and other things. So people are attacking her on X because of stupid things. So Melanie is also, people are attacking her personally, which is not appropriate. So, yeah. And I could be wrong, of course. I could be wrong. I'm not God. I'm just one man who saw the trial and I saw the testimony and I disbelieved it. But I'm not like in some superior position. It's not like I'm able to see something fundamentally that you can't see. We both watched the trial. So we're both looking at the same thing.
2020 CF 3014, State versus Ashley Benefield. Ms. Benefield is here present in court along with her attorneys, Mr. Taylor and Mr. Pinnell. Present for the state is Ms. O'Donnell and Ms. Friel. Ms. Benefield was found guilty by the jury on July 30th, 2024 of manslaughter with a weapon. It's a lesser included offense of the original charge and it's a felony of the second degree. The jury did make factual findings of actual possession of a firearm, discharge of a firearm, and causation of death or serious bodily injury with a firearm. As a result, the statutory maximum becomes 30 years.
I believe the minimum is 15.
What I've reviewed in anticipation of sentencing.
I believe the range is 15 to 30.
Tell me if there's anything that I was supposed to get and review that I have not. I reviewed the information in the file as well as the verdict.
I find the whole situation just very interesting. I find the whole situation very interesting. And then I also took note that some people were attacking me personally because of my opinion, which also is interesting. But we all, kind of strike out where we do. Yeah, that's what can you do?
Form. I reviewed a score sheet that I believe was provided as a part of the sentencing memo. I don't have the original from the state. If you could hand that up. Yes. I reviewed the pre-sentence investigation, and Mr. Taylor, I know
they didn't find her guilty of second-degree murder. Yeah, I think Court TV is wrong because Court TV said, "Oh, she's facing 30 years after they found her guilty of second-degree murder." I don't think they did. I think they found her guilty of some version of manslaughter. Yeah, I think that's why I'm confused. I think Court TV's wrong.
It referenced various mistakes and inaccuracies throughout your presentation. If you want to point those out and what you disagree with, please feel free to do so.
Yeah, they came to a compromise verdict. That's right.
I've also reviewed the court file.
They split it. They didn't find her guilty of second degree. They found her guilty of manslaughter.
I did review the defendant's sentencing memorandum and the attachments, including case law, letters, and emails. All right, Mr. Taylor, have you had sufficient time to prepare, and are you ready to go this morning?
Yes.
All right. State, have you had sufficient time to prepare, and are you ready to go this morning?
Yes.
Court TV's
lying. So the score sheet that's been handed up appears to be the same one that was attached to the defendant's sentence memorandum. It's got manslaughter with a weapon. That's a level 8 offense, 74 points. The victim injury points are scored at 120. Total sentence points of 194. Once you put through the sentence computation, gives the lowest permissible prison sentence of 124.5 months in Florida State Prison. Any objections to the score sheet?
No, sir.
Which is 10 years, 4 months. I can do that math in my head. All right.
So I know this defense, you received the PSI because you had mentioned it in your sentencing memo. State, did you get a copy of it?
I did.
All right. Same as I told Mr. Taylor, if there's any objections, additions, corrections, deletions that you want to mention, please feel free to do so throughout your presentation today. So how I do these sentencings, whenever I have an open plea or if it's a sentencing after trial and the defense is going to seek a downward departure, I generally start with the defense, presentation of evidence, then I go to the state, and then I come back to the defense. Just because you carry the evidentiary burden, I'm sure you've discussed this with Ms. Benefield, But just so I have it on the record, Ms. Benefield, today throughout this sentencing hearing,
gonna super
you and
chat,
your attorney is going to be
Melanie,
arguing for what we call a
just to
downward
say
departure.
sorry.
And that is where you're going to be asking the court to go below the
What do you think is the right
guidelines
super
of the
chat
lowest
amount for
permissible
sorry?
sentence of 124.5
I'm not trying to
months.
start shit. I just
In order
genuinely want to
do
start
that,
sorry.
there's
Do
an
I super
evidentiary
chat her?
burden on the defense, and that is to prove
send her
by
a super chat? Would that be a good thing to do?
Substantial evidence that, one, you qualify for a downward departure, and two, that it's the most appropriate sentencing option, and that the court should exercise its discretion to do so. So because you carry that evidentiary burden, that's why I generally start with the
No?
defense,
Okay.
then go to the state, and then come back to the defense. It's maybe the same or different as other judges do it, but if you want to do that, that's how I normally do it. If you prefer to do it the traditional way, I'll do it that way. Mr. Taylor?
I'm fine proceeding as the court suggests.
All right, sir. And then, of course, the closing, opening statements and closing arguments are all the same. All right.
Well,
Yes, sir.
it was an idea.
I assume we will handle the departure aspect first, and then I will go into my closing.
Absolutely. Before we get started, I would imagine that there's going to be a number of folks who are going to make statements today, either pursuant to Marcy's Law or victim impact. And certainly this is not a capital case, but as if you've done a sentencing in front of me, you know that I generally follow the dictates of 921-141 and 921-143 on what's appropriate and permissible as the scope and nature of victim impact statements. State, have you had a chance to speak with the folks who are going to talk today and let them know that information?
Yes.
All right. And I don't know, Mr. Taylor, if how many people are going to speak today, or if anybody's going to speak. Certainly I received the stack of letters as part of the sentencing memo. If anybody is going to speak today, were you able to speak with them about the nature and scope of a statement to be made?
We're only going to have one witness.
I look mischievous. I'm not trying to be mischievous.
All right, fair enough. All right, with that said,
I feel like an ass. By the way, that's part of the reason I spent so long talking. I feel like a jerk, because I like Melanie and I wasn't trying to do anything wrong, but I kind of feel like a jerk. Yeah. I'm not sure exactly where I went wrong, but it doesn't feel good inside. It doesn't feel good inside.
Mr. Taylor, would you like to make any sort of opening statement? Or I'm going to address you mostly, Mr. Taylor, but if Mr. Pinnell, if you're handling part of it, please feel free to let me know. Or would you like to make any sort of opening?
Not necessary.
All right. State? Okay, then I'm ready for the presentation of evidence. Mr. Taylor.
We will call Barbara Russell, Your Honor.
I still think Ashley Benefield is a lying murderer, but I don't want that opinion or belief to wind up in personal problems between me and another creator. It's not worth it, man. It's not that strong a belief, damn. Or at least it's not a belief worth, worth breaking a relationship
just about
over.
12 to 15 inches from the microphone. It does adjust up, down, left, right. But if you just speak in a loud, clear voice, we'll be able to hear everything.
Good morning. Would you tell us your full name?
Barbara J. Russell.
And tell us a little bit about your education.
I have a master's degree in clinical social work. I have a doctorate in clinical psychology.
And the current position that you hold employment-wise?
I am self-employed. I have a clinical and forensic mental health practice.
How long have you had such a practice?
For about 15 years.
Would it be correct in addressing you as Dr. Russell?
Yes, certainly.
All right. Dr. Russell, have you appeared before in the courts of the state of Florida and been recognized as an expert?
Yes.
And can you give us an idea of approximately how many occasions?
Typically, I testify in court as an expert in the state of Florida about 3 times a month. for the last 8 or 9 years.
Have you, in that capacity, appeared in the courts of Manatee County?
You had a dress with that same
on a
print in
regular
1991?
basis?
Yes, sir.
Yeah, I was thinking something
Have
about
you
the dress
appeared
seemed a
before
little
Judge
bit off.
White
Is
in
it because it's
previous
dated?
proceedings as an expert on,
Was that the problem? I was like, I don't know about
Yes.
that top. Okay.
I want to ask you, Dr. Russell, amongst your other specialties, are you qualified to diagnose and treat PTSD?
Yes, it's one of my specialties in both my clinical and forensic practice.
All right, would you tell us what PTSD stands for?
Post-traumatic stress disorder.
And are you also qualified, in addition to PTSD, Dr. Russell, to treat?
Her overall look I
domestic
describe as
violence
kind of like
abuse?
fierce.
Yes.
Can
like,
you give us
I
an
don't know.
idea of your experience in the domestic violence area on behalf of both abusers and abused?
I'm a nationally certified domestic violence clinical specialist. I have treated victims since early 1990 in various outpatient services, providing support groups, individual counseling. I have, for Circuit 12, provided court-ordered domestic violence intervention classes for offenders for about 8 years.
Right, and among other instances, have you been involved with the Batters Intervention Program as well?
Yes.
I want to ask you a few questions about Douglas Benefield. Did you have an opportunity in your capacity as a psychologist to interview him?
Yes.
You know what? I
Do you
can put it
recall
up to
approximately
1.25,
when
make it a
that
little bit faster.
would have been?
That would have
Let's
been
do
in
that.
April of 2020.
And approximately how long did that interview last?
He spoke with me for about 90 minutes.
Were you satisfied
better.
during the course of that interview that you had sufficient time to render a diagnosis of Mr. Benefield's personality?
Between that interview and also the collateral data, the documentation that I viewed, yes, very much so.
Would you tell us what that diagnosis was and your basis for it?
Douglas Benefield exhibited criteria that met the diagnostic categories of narcissistic and antisocial personality disorder.
And how, if at all, would that fold itself into being a potential abuser?
Well, the antisocial components, as well as the narcissistic components, he had little to no empathy. He really lacked the capacity to take responsibility for his behavior. He had a desire to be admired, to have constant attention. He felt very entitled and demanding to the attention and admiration of other people, whether or not he did anything to deserve it. And he had little regard for the rights of other people.
Are you familiar, Dr. Russell, with Ashley Benefield?
Yes.
Do you have an opinion as to whether or not Ashley Benefield, as she sits here today before you, is currently suffering from any specific condition?
Yes.
Would you tell us what that is?
Ashley is suffering from post-traumatic stress.
And are you able to give us some insight into the basis that caused that syndrome that she suffers from?
It's really been caused by complex trauma. The root cause all comes down to the abusive relationship with Douglas Benefield. From the time the abuse began in their marriage up until the incident of the attack that led to the shooting on September 27th, there have been multiple situations that have severely distressed and traumatized her.
So I want to ask you a couple of questions about post-traumatic stress syndrome, and I'll use as an example the soldier that comes home from combat. Is there anything about this syndrome that requires or necessitates an instant response to stimuli immediately after the traumatic event? Or
No.
is that liable to happen at any time over the spectrum of
PTSD can be
conditions and
delayed
circumstances
significantly.
that individual may experience?
The symptoms can be delayed onset. So somebody can experience a severe trauma in January and perhaps not exhibit any kind of
Yeah, I remember reading an article about
reactivity or
that when it came
stimuli
to
that reminds them of
veterans.
that, or any emotional
It's like
distress
more
for
than half the
days, weeks,
time
months,
still illegal
even
on set.
years later. So it's not unusual to see in November somebody have a problem, or
That's
even
right.
again years
I remember
later.
reading that.
Delayed onset's common.
So again, using this hypothetical soldier as an example, 3 months after they return home following combat duty, they may not respond to any stimuli, but you're telling us as long as 18 months, 2 years later, when a spoon happens to fall into the garbage disposal and makes a clattering noise and they dive onto the floor, that would not be unusual.
No, it would not be.
I know that's the right answer.
Are you
I've
familiar,
read that
Dr. Russell,
myself.
with the facts
But
of
something
this
about
case,
the way she presented
circumstances
just
surrounding
is
the
like
shooting?
harsh.
Yes.
I don't know.
Do you have an opinion as to whether or not Douglas Benefield's conduct contributed to his death?
Absolutely.
Objection and proper opinion.
Overruled.
Yes, absolutely.
And how so?
Douglas Benefield had a history of violent behavior. Douglas had been threatening Ashley, becoming increasingly aggressive in the weeks and days leading up to the shooting. He had been making verbal threats to her life. He was in her home. He was refusing to leave her home. He was acting in a manner very typical of Doug, only exacerbated at that time. He behaved in a manner that made her feel as though her life was in danger, that she was at serious risk of being killed or being seriously hurt.
I object to that answer because it goes against the jury. We're no longer in the guilt phase. We are in the or no longer in the liability phase. We're in the damages phase. So it's like, oh, he was behaving this way. It's like, no, he wasn't. No, he wasn't behaving that way. I know that for a fact now because the jury told me. You're trying to redo the trial, ma'am.
Did there come a time, Dr. Russell, when you were approached by representatives of the Manatee County Sheriff's Office who asked that specific question?
Yes.
Did you respond to them with basically the information you've given us here today?
Yes.
Tell us about whether or not you have formed an opinion as to Miss Benefield's psychological state at the time of this incident.
At the time of the incident, she was acting under extreme duress. She was in full survival mode, fully believing that her life was in danger.
I object to this
She
answer.
was responding with an effort to stay alive.
I object to this
There's a
answer.
process that happens in the human mind when we feel that our lives are in danger. We have to make survival decisions, and these decisions are made in fractions of seconds. Even outside our conscious awareness, we're assessing the situation, assessing our capacity to escape, assessing our capacity to fight back. And people make decisions based on what their survival brain, as I call it, tells them is going to keep them alive. She was doing what was biologically natural in a situation where somebody would feel that their life was in danger. And this was also compounded by the weeks, months, years of knowing Douglas Benefield to be violent and being afraid of him.
Did you, Dr. Russell, have any opportunities to actually observe Ashley Benefield's reaction around males and the manifestation of this post-traumatic stress syndrome and her comfort level?
Yes.
Tell us about it.
In the weeks, really the early months following the shooting, when Ashley was staying at my home, I would notice in particular, she would frequently apologize for things that didn't require an apology. She especially did that around my husband. If she was in the kitchen making a protein shake in the morning and he came in to make coffee, she always felt like she was in the way. She was always very quick to say she was sorry, to kind of flinch or pull back in a manner that was just completely, appeared to be unnecessary based on the situation. You know, there was never any indication from him that she was being bothersome in any way. But she had an expectation that she was going to get yelled at or that somebody was going to be mad at her. I had noticed another occasion My son had stopped by our house in the evening. It was dark unexpectedly. She looked out the window and saw a male figure approaching, and she came screaming through the house saying, someone's here, someone's approaching the house. She was very hyper-aroused and reactive to situations, particularly with men.
Your Honor, I don't believe I have any further questions for Dr. Russell.
I object to some of those answers on a technical legal level, because some of those answers are undermining the jury's conclusion, and I don't really think they're appropriate for sentencing. It's like, oh, she was feeling this. Oh, she was feeling that. It's like, was she? Was she feeling those things? I don't know, man. You know who would know? The jury. Because you know what the jury does? They're literally the finder of fact. It's literally their job. And the jury concluded guilt. So what do we do as a matter of law? Well, we can conclude the jury found any fact that would support the conclusion, and we can conclude the jury dismissed any fact that would undermine the conclusion. We can conclude the jury found every piece of evidence that would support the verdict. We interpret it in support of the verdict. So it must be true that those things aren't true, because the jury found guilt, and those things would undermine the jury's verdict. So those things can't possibly be true. So I object to some of those answers on a technical legal level. It feels like we're trying to redo the trial a little bit, to be honest.
Are you familiar with something called histrionic personality disorder?
Yes.
Can you explain what that is?
Histrionic personality disorder is a pervasive pattern of a person being very melodramatic to gain attention.
And are you aware that the defendant in this case has been diagnosed with that?
I'm aware that that's a false diagnosis, but yes.
So in your opinion, it's a false diagnosis?
Absolutely. Women who've been victimized by domestic...
I asked a question.
Excuse me. She's Dr. Russell.
Let her finish. Go ahead, ma'am. You finish your answer.
Yes.
It's a false diagnosis.
Women who have experienced victimization of
Okay.
intimate partner violence are often mischaracterized as being histrionic when the individual assessing them does not have a proper understanding or a complete picture.
Oh,
of
it
what's
must
been
be that
going on
they're
in their
ignorant.
lives.
It must be that I don't like that answer either. That answer feels very elitist. It's like, oh, it must be that they're ignorant. It must be that they don't have familiarity. It must be it can't possibly be that another person came to a different conclusion than me. That can't possibly be true. How arrogant of you, doctor. Although then again, you're a psychiatrist, so it comes with the territory. Doctors and lawyers, man, we're pretty arrogant sons of bitches sometimes.
That background, and you are able to diagnose it quickly.
Absolutely.
And would you consider yourself unbiased when it comes to Ashley Benefield and Doug Benefield?
Absolutely.
Okay.
Really? You're
So
unbiased. That's
after
interesting.
you
Wow,
had
that
your
must be
initial
great
evaluation
for
of
you.
Ashley Benefield, that was in, I think, April of 2020.
Correct.
You continued contact with her,
Correct.
and she had your phone number,
Of course, all of my clients have my phone number.
and she would call you on a regular basis.
She would call me on a regular basis to update me on what was going on in her situation, per my instruction, as there was potentially an upcoming court hearing regarding her situation.
And she would copy you on emails to her attorney.
I don't know. I don't recall that.
There were several emails that were sent to her family law attorney that had you CC'd on them.
Okay.
Would you agree with that?
That's a real possibility.
So as a therapist, is it normal to have a client CC you on their correspondence with their attorneys?
Yes, if I'm involved in a capacity where I could be testifying at a family law hearing or at an injunction hearing. That's very typical.
Okay. So several weeks, I suppose, after this homicide, she moved into your house.
Yes,
And your house, she lived with you, your husband, and your daughter.
correct.
And she lived there approximately a total of 8 months.
Approximately, yes.
And the night that the shooting occurred, you were called on the phone.
I was called by her attorney, yes.
Okay. And you showed up to the house where the murder happened.
Where the shooting happened, yes.
Okay. And that's a normal part
Where the murder happened, where the shooting happened. Dude.
of being a therapist. You show up at somebody's house when there's been a crime.
I have shown up at people's houses, at their place of employment, at a hospital emergency room. Crisis intervention is very much a part of being a mental health professional.
And you know about the demonstrators that were out in front of the courthouse on numerous occasions during this case, correct?
Yes,
Holding signs, Free Ashley,
Yes, that's the Community Defense Committee called We Stand with Ashley. I'm familiar with that.
On numerous occasions, you were also out there holding signs.
Yes.
And marching with this group.
Yes.
And you still consider yourself unbiased?
Absolutely. It's part of my ethical obligation as a licensed clinical social worker to be involved in situations that involve injustice.
Now, you said that you were able to diagnose Doug Benefield after a 90-minute phone conversation and I believe you said collateral documentation.
Yes.
And a lot of that collateral documentation a lot of it included the paperwork.
Wow.
That Ashley Benefield was trying to get.
She doesn't have a lot of respect for what happens on my side of the house, does she? Damn.
The recitation of what Ashley said Doug had done and the things that she was trying to tell the court that Doug had done, trying to get the injunction.
No, that had nothing to do with my...
You may be a psychiatrist, but you're in my house. You're in my house. This is where I live. This is law, baby. Whoa.
Forming my opinion. In fact, the documents that I looked at that formed my clinical opinion of Douglas Benefield were mostly things that he documented, that he wrote, that he did. It was based on his behavior, not what somebody else says about him.
But it did include what Ashley Benefield said about him.
Not the documentation that I formed my opinion about him. Absolutely not.
Are you saying that what Ashley Benefield told you had nothing to do with your opinion?
My opinion in what was going on with him clinically had to do with the words that came out of his mouth as he talked to me for 90 minutes and the various correspondence and documentation that came from him, his emails to other people, things that he had documented, things that he told me that he did.
Okay, so after
I do not like this woman.
this evaluation,
I do not like this woman one bit, man.
you said, I believe, that Doug was increasingly violent and
She is arrogant.
more daughter, right?
Yes.
And you knew this because Ashley's telling you this.
Yes.
She's
You didn't witness
she's
this.
arrogant. She's looking down her
No,
nose
the only
at
thing I
me.
witnessed were some of the text messages that he was sending her.
Okay, but you never saw any of the other evidence that he was becoming increasingly violent?
No, it was what she was reporting to me that he was saying and the messages that she was forwarding, some of which were quite threatening in nature.
I have no further questions, thank you.
Redirect?
No, sir.
All right.
Yeah, I wouldn't
Thank you very
redirect
much,
that
ma'am.
either.
Thank you, Judge
I
White.
feel like just let that sit too.
All right. Did you have anybody else that either had
What an
testimony or
arrogant
wanted to
prick of a
make
doctor.
statements?
Statement by me, no further
Oh, just closing?
Thank you, Dr.
Look at the
Rush.
way she walks
Just
too.
closing.
As
She's like she's doing some power walk out of there. Holy
Yes, sir.
shit, dude.
All right. State, did you have any victim impacts?
The disdain. The disdain. I can feel it. I can feel the disdain just radiating off of her. Woof.
Statements, any letters, anything that you wanted me to consider?
Yes, I have several people here that would like to speak, if now is the time.
Yes.
I would
Your Honor,
like,
I'm sorry.
Oh, she's a social worker with a psychology degree. She's not even a psychologist or a psychiatrist. Oh, I'm sorry. Oh, she's just a social worker with a psychology degree. Oh, well, at least she has the psychology degree. I gave her way too much credit. Okay. She has a PhD. She has a PhD though, and she's a licensed social worker and mental health professional. Okay. But not a psychiatrist or a psychologist. Okay. Corrected.
Sure the court didn't misunderstand. I did want to make a statement about the departure issue consistent with the testimony that the court just heard from.
Okay. Yeah, what I meant is I normally let the defense go first. So if there's any witnesses you want to put on in support of downward departures, any evidence you want to introduce in support of downward departures, anything you want to have me hear about sentencing, I want to hear all of that. And then I'm going to go to the state and I'm going to hear any evidence they want to present, testimony they want to present, victim impact statements they want to present. I do it globally.
Okay.
Fair.
So you want the whole shebang now?
Yes, exactly.
All right, fine. I'm ready.
Oh, okay. All right.
So let me.
Well, hold on. Let me make sure we need to be on the same page.
Yeah.
At this point, I'm still in the evidentiary portion. So if there's anybody else, if there's any other letters, cards, statements, other information you want me to consider, if there's any statements that any witnesses want to make here in open court in support of Ms. Benefield, I'll be happy to hear all of that. If it's argument in favor of the downward departure, I will hear that after I hear from the state and their witnesses.
Okay, and that was my initial understanding. Then once I give that, I will then complete my remarks as to sentencing.
Absolutely.
Okay.
Once we finish with the evidentiary portion, then I'm going to go closing, closing, closing.
Understood. Thank you, Judge.
Yes, sir. Absolutely. All right, state.
so the first person, Judge, is Dave Benefield. It was Doug Benefield's brother. Statement.
So I'm confused. Does the defense no longer have
And
no
I'm going to
further
have them
witnesses?
sworn in.
I'm sorry.
Even if it's a statement, they'll be sworn in.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
I thought I understood. I thought that I thought the judge just said the defense needs to present all the evidence, and now the state's calling a witness. Are there no other witnesses for the defense? I'm confused.
Sir, if you could please state your full name for the record and then tell me what you want the court to know.
I'm David King Benefield, and I'm just wanting to provide a victim impact statement.
Yes, sir.
Thank you.
Yeah. So it sounds suspiciously like the defense has no other
I
witnesses.
want to thank you
It's odd.
for your excellent and just governance as you presided over this trial. Throughout this entire tragedy, I witnessed the steady progress of the due process of law that is meant to be at the heart of our country's justice system. To you, to Manatee County, to the entire Sheriff's Department, and to the state's prosecution team, I offer my deepest and most heartfelt appreciation. It is impossible to convey the depth of loss and grief that I feel daily at the death of my brother, Doug Benefield. On Monday morning, September 28th, 2020, Eva Benefield, my 19-year-old niece, called. She worried that she had not heard from her dad. He was not answering calls, which was very out of character for him. And soon after, I received a phone call that my brother was dead. On a call that included my cousin, Tommy Benefield, and Doug's family law attorney, Stephanie Murphy, we added Eva to the call. Eva immediately asked what was up with her dad. I was in a state of disbelief and shock. I couldn't get the words out of my mouth. Before I could muster up the words to answer her, Eva exclaimed, "She killed him, didn't she?" The next couple of days are a blur as we spent time processing Doug's life, his death, and how to respond. Tommy and I picked up the U-Haul with Doug's belongings from Alicia's house, consolidated his few remaining belongings at his apartment in Bradenton, found where Sully had been boarded up for their planned move, then headed to South Carolina to meet up with Eva and to meet her needs. There were decisions to be made, belongings to consolidate, bills to be paid, and now the unthinkable decisions about investigations, communication with family and friends, autopsies, and the unfathomable what to do with Doug's body. Doug's body was still in Florida following an expedient autopsy. I just had to see him before he was cremated. I struggled to believe it, and I needed to see him. Up until that point, I had not cried. I was numb. Tommy and I went into the office of the crematorium while they brought Doug's body out. As I looked at him through a stained glass window, I began to weep, and I could not stop. As we got into the car, my weeping turned into loud wails. Tommy sat with me in the car while I wept and wailed uncontrollably. I have never experienced anything like that kind of grief and emotional pain. As I sat there, I had one of the most profound moments of my life. I trusted Jesus Christ as my Savior in 1985. I was living with my brother, Doug, while we both attended Texas A&M University. We had heard that our Uncle Doug, a test pilot and a hero to all of us, had been killed in a B-1 bomber crash. My brother Doug was named after him. Following Uncle Doug's death, my brother played an instrumental role in leading me to Christ. He witnessed the immediate change in my life. I dropped out of my fraternity. I spent hours reading the Bible and learning to pray. Jesus captivated my heart, and the old destructive habits just fell away. Depression left and joy came in. Where I had felt so lost, I finally had a direction for my life. Doug and I shared our faith journeys from that time in college until his death. As I sat in the car at the crematorium, wailing and gasping for air, I did what I had learned to do all those years ago with Doug. I prayed. My prayers were my thoughts screamed to God as loud as I could think in the midst of my uncontrollable crying. I felt the strong and clear answers of the Lord with each prayer I prayed. I asked God, why do I hurt so bad? God responded, because you loved him so much. Why did I love him so much? God's response was a series of images and memories that came flooding back in rapid succession. I remembered him letting go of the sissy bar on my first bike ride without training wheels and laughing as he shouted, "You can do it, just keep pedaling." I remembered his encouragement at my first high school wrestling match. He was a very successful athlete and was always a state contender in wrestling. I was hyperventilating at my first match, and he was there to encourage me and help me overcome my fears. I remembered him taking me to a New Year's Eve jazz concert in Austin, Texas, during my first year in college. He knew I didn't have the money, and he paid for everything. I remembered even the little things that he made so special on that trip, like my first bagel covered with cream cheese and jelly when I didn't even know what a bagel was. To this day, every time I eat a bagel and cover it with cream cheese and jelly, I think of him. I remember his designer shirts that he let me wear, his coaching comments after my first fraternity meeting as president, the bedroom he built for me in a closet in our condo at Texas A&M, him gently but firmly correcting me after breaking his prized car when I took it out for a midnight joyride. And I remember my first cup of coffee in college that he made for me, and on and on. While these images were flashing through my mind, I heard the Lord impress me with this thought: you shared so many of your firsts with him. And the conversations with the Lord went on for quite some time. Why do we grieve with such pain? It is because of the glorious privilege God gives us to love deeply. I lost my dad to cancer at 12 years old, and my mom several years prior to Doug's death, but nothing hit me like this. God blessed me with two great brothers, and Doug, 2 years older than me, was such a gift to me. He was truly a hero in my life. Every day, I feel a kick in the gut from the loss of my brother Doug. I have spent hundreds of hours going through his well-kept records, literally tens of thousands of pictures of Ashley and Emerson, emails and texts, as I have ordered his affairs and tried to find anything that would explain what happened or that corroborated Ashley's version of the events. Rather, what I have found in his journals, his extensive emails, and meticulous records was a man with his heart set on loving his family well at all costs. I grieved Doug's loss so much because I loved him so much. He was strong, but he never used his strength to hurt people. He used it to serve and to love and help people. Doug made life so much richer. He had so many unique facets. He was an amazing artist. He was a defender of the weak, a visionary, a strength that would comfort you, not concern you, a laugh that made everything seem okay, and a way of including you that made you feel deeply loved and appreciated. He generously shared his discoveries of the beauty of life. When I was with him, everything seemed so much more exciting and hopeful. His friendship humbled me. His giftedness amazed me. His kindness comforted me. His strength strengthened me. And his passion for life inspired me. Doug was patient, almost to a fault. He hoped and he trusted deeply in the Lord with an unshakable optimism. He graciously endured so much suffering on behalf of the others, as was witnessed in his astounding patience with Ashley. He genuinely believed the best about others. This can come across as being naive or gullible, and in our weakness, that is certainly a danger. This can also make you an easy target for people, but it is truly a great way to live. I will never forget talking to Doug on the phone the first time I heard about his relationship with Ashley and the hope he had for their future. He eventually told me of his hopes for their marriage, their daughter, and all the endeavors they dreamed of in their future. I could not have imagined a more horrific ending to their story. I knew my brother intimately. Doug was absolutely not the monster Ashley alleged him to be. He was the complete opposite of what the defense was presented. The primary evidence against Doug was his sworn testimony in family court, where he admitted to actions he deeply regretted that occurred on a single day 3.5 years before Ashley killed him. The defense presented a slander campaign based upon gross exaggerations of Doug's own testimony and unverified allegations from Ashley. Doug patiently endured Ashley's verbal, emotional, and legal abuse for over 3 years and was still willing to reconcile with her, even serving her up until the time of his death. The month before Doug was killed, I spent 4 days with him in Mount Pleasant, South Carolina. He expressed to me his desire to help bring healing to Ashley and her mother from the trauma that they had experienced in the past. Doug realized he might not be able to salvage the marriage. He was resigned to being a single father and working with Ashley to care for Emerson. He was not angry or bitter, but filled with mercy and resolve to make the best of the situation. That was the brother I knew. His love and compassion for his family was unshakable. Ashley, I want you to know that I forgive you. You have caused me the greatest loss that I have ever experienced, one that almost daily causes me to completely stop what I am doing and weep from the overwhelming loss I feel. Doug touched every part of my life, and I can't process this senseless tragedy. But as Christ has forgiven me for my wrongs, I also forgive you. I do not hate you. I grieve for what your actions have and will cost you. It is again the exact opposite of what Doug sought for you and for Emerson when I think of you. I pray for your healing, the healing of your family, and for God's grace over Emerson as she grows. This is the very same thing that Doug told me was his desire for you 7 weeks before his death. Little did you know that the man that you sought so aggressively to get out of your life was a gift to you who had counted the cost to love you no matter what the cost, even his life. I found out after his death that there were many people who strongly encouraged him to leave you, even some who expressed concern for his life, but he would not give up on you. Ashley, Doug's love was but a fraction of the love that God has for you. And I pray that you will experience God's forgiveness and mercy that only comes by knowing Jesus Christ and his cross and truly believing in him.
Okay.
All right, thank you. State.
Next, we have West Benefield.
I wonder if during a victim impact statement anyone has said, I hope you come to know Allah.
All right, sir, if you could please give me
sure
your
it's
name
happened,
and then
but-
tell me what you want the court to know.
Yes, sir. My name is John Wesley Benefield Jr., Doug Benefield's older brother.
Yes, sir.
Thank you, Your Honor, for allowing the Benefield family to be heard. I ask the court to give Ashley Benefield the longest possible sentence for the egregious cold-blooded murder of her brother Douglas Glass Benefield. Doug has always been a man of faith, loved his family, loved this country, and his friends. The Benefield family has had a very long history for many generations of protecting this country, protecting others, helping others. Doug was a naval aviator after graduating from Texas A&M. Went on to do great things in life. Doug has a beautiful, smart daughter, Eva Benefield, who does not have a father anymore. Unfortunately, Eva's mom, Renee, passed away a number of years ago due to health issues. We all miss Renee, a wonderful wife, mother, and person. Ashley Benefield had an opportunity to make a great marriage, a partnership with Doug, be a great stepmom to Eva. We all know now what Ashley has done by murdering Doug in cold blood. Ashley doesn't care. She didn't care about Doug. She did not care about Eva. Ashley treated Eva horribly, while Doug and Ashley were under the same roof in the beginning of their marriage. When Ashley had Emerson, their daughter, Ashley did not even tell Doug that she was born. As we found out in the jury trial, Ashley did not even recognize Doug as the father on the birth certificate. That's my understanding.
Judge, excuse me, I apologize for interrupting. I don't think attacking the defendant is part of a victim impact statement, so I can probably just ask the witness to move on to a different part of the statement.
I'll sustain.
Ashley treated Eva horribly while Doug and Ashley were under the same roof in the beginning of their marriage. Here? Yeah. The Benefield family has always been a very close family. We always had a great time together when we were all able to get together. We would catch up, have great meals together. We have a great God-loving family. Now we do not have Doug anymore. Eva does not have a dad anymore, or a loving mother, Renee. I'm retired law enforcement, retired deputy, Brazoria County Consul's Office, Texas, the south side of Houston.
Yep.
As a
I
court, the
believe
sheriff's
it.
office and the state
I
attorney's
definitely
office
believe you're a
have
sheriff,
seen,
Texas.
dealt with
Yep,
animals that
100%.
murder, steal, rape, home invasions, pedophiles, so have I. When you look at these egregious offenders, once they get out of incarceration, many of them go back to the streets and continue to commit the same type of aggravated offenses until they're caught again. During the jury trial, Ashley would occasionally look at me and my family with this arrogant smirk, showing that she...
Same objection. I apologize for the interruption.
Sustain.
In conclusion, I respectfully ask for the full sentence of incarceration due to the cold-blooded murder of Doug Benefield. I'll give you one last example of how we know Ashley doesn't care about Doug and the Benefield family.
Again, objection. Same
Sustained.
basis.
Objections during a
Your
victim
Honor,
impact statement.
thank
That's a
you again
new
for allowing
one.
us to be heard.
Thank you, sir.
I mean,
State.
it's not that he's legally wrong, but I don't know, man. I don't know. Objecting during a victim impact statement, unless it's like really egregious, I don't know, man. I don't know about that one. Okay.
Tommy Benefield?
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, sir, if you could give me your full name and then tell me what you want the court to know.
Yes, sir. Tommy Douglas Benefield, Jr. I had one younger brother, but my relationship with Douglas Glass Benefield was even closer than that. Douglas was named after my father, a very famous Naval Air Force aviator, test pilot, combat veteran. And Doug followed in the footsteps of my father, much the way many of our Benefield family did. We heard from the expert who spent 90 minutes with Doug, but I spent 59 years with Doug. We knew him much better than any 90-minute expert. Before Ashley was born, Doug was a graduate of Texas A&M in biology with scores high enough to get into medical school. Because Doug was raised in a very middle-class family, did not have the money or scholarships like today to go to medical school, he chose to go into the Navy program that I helped sponsor him into, which led to him spending 3 combat tours off of aircraft carriers in the Western Pacific and in the Middle East. Doug was both a naval flight officer, meaning that he was a warfare officer, aviation warfare officer, and he also flew the airplane, which was unusual at that time, but something that he could do, like many other things. In 1992, he went through 1-year training as an intelligence officer for the U.S. Navy and eventually for the Defense Intelligence Agency. During all those trials and tests in the Navy and in the intelligence plans and purposes, Doug was always tested to the highest levels to make sure that he could
You don't hear
withstand
about
the
them every
stress of
day.
combat, the stress of life,
One of the more forgotten
and separate those
intelligence
two things
agencies.
well.
Sometimes.
After becoming an intelligence officer, his other job, his public job, was as a mine warfare officer and instructor at the Navy's Mine Warfare School in Charleston, South Carolina. He did that for 3 years. After that, he went 3 years for the Defense Intelligence Agency as an analyst and a technical operations expert. In
So it
1999,
was
he
Jack
left active
Ryan.
service, but stayed in the reserves and continued his service to this country for almost 20 years. In 2000, he married Renee, his longtime amazing wife. In 2001, their daughter Eva was born, who's here today, and you'll hear from after me. 2015, after a long run, Renee passed away, despite what the defense has alleged, of a heart attack under natural conditions. Doug became a single parent, like I was many times in my life, unfortunately, and in 2016, he met Ashley. I met Ashley April of 2017. I remember the first encounter. I remember being at the home at 701 Preservation Place. I remember the calm and comfort, the love between them at the time. But a few months later, Ashley separated from Doug under one purpose, saying that she was having trouble with her pregnancy, but with ulterior means. And that is the history that we know through this process. What we don't, most people know about Doug Benefield is when he was 12 years old in 1971, like Doug, who could figure out things that no one else could for this country, for the special operations warfare operators, for the emergency responders, Doug, Wes, and David's father figured out how to use microwave and laser systems to communicate and track space objects before anyone understood what that was capable of. That was 1971. Like Doug, was passed on to him one of Doug's current technologies that no one in the world could figure out but Doug. It's called transpositional modulation. It's a radio frequency waveform technology that offers dramatic bandwidth increases and novel security functions for existing wired and wireless networks. There's a multi-billion-dollar corporation founded on the fact that Doug Benefield could figure out how to make two signals go on the same frequencies at the same time. That accomplishes what no one thought possible, the simultaneous transmission of two or more distinct data paths on a single carrier signal.
Isn't that just a fast Fourier transformation? Or is that something else? Because, okay, like the modulation of different frequencies. Yeah, wasn't it? It wasn't Doug. It was what's her name? The actress who invented it. Whose name I always forget for some reason. The Hollywood actress who invented basically modern radio. What was her name? I should know this. Lovelace? Hedy Lamarr? Yeah. So yeah, Hedy Lamarr. Yeah. So yeah, wasn't it Hedy Lamarr who basically invented that? Not so much Doug. Yeah.
Quantum physics in use on 5G networks all around this country today. He also founded the patents that would lead to secure data via quantum physics that encrypts swiftly and securely all data that's unhackable even in today's world. Right now, here's just some of the patents that are in use under Doug's name. Lighting control devices and methods. Task ambient heating and air conditioning systems for distributed space conditioning. Methods and systems for air quality analysis, diagnostics, and environmental controls. Heating and air conditioning fire suppression systems. And even the most craziest one of all is called free space optical transmission system for vehicle networking. The reason that your cars, more importantly our special operators all around the world in the Western world, can data transfer from sole operators behind enemy lines to their command and control is because Doug Benefield figured it out.
Okay.
John 10:10 says to us,
So he was a really, really smart guy.
the thief comes only to steal and destroy,
Okay.
as opposed to
Incredibly
Christ,
smart.
who's come that they may have life and live it to the full. I believe that the people who have supported Ashley have been deceived. They've had stolen from them their time and their effort. That
Judge, under to object on the same basis, it's not a proper victim impact.
Sustained.
There's been no question in my mind or in this court under the stand your ground hearing, which was found that Ashley did not have a self-defense enough to reach that threshold, that she stole from Doug. There's no question that she killed Doug.
Judge, same objection. I'd ask the state to direct the witness to give appropriate victim impact.
Judge, I would disagree. It is allowed that the victim's family can make statements about the defendant. I understand if the defense is asking that they not, make broad
Characterizations and opinions about the crime, the defendant, and the appropriate sentence shall not be permitted as part of a victim impact evidence.
I'll take care of that, Your Honor. I'll
Yes,
make sure.
Thank you.
And you're reading that from?
921.141 sub 8. How I started the sentencing hearing was, this is not a capital sentencing. However, when I do sentencings, I think those are good guidelines to use in formulating the nature and extent of a victim impact statement.
No problem,
Fair
sir. I'll
enough.
wrap it up, and I'll be careful.
Sir, tell me everything you want to know. The victim impact evidence is designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death.
Yes, sir. I believe I've done that so far, and I'll finish it with that, sir.
Fair enough.
What saddens me personally is the loss of Doug to our family, to Eva in particular, who has no parents, as she said.
So if I understand correctly, the judge is using the restrictions that apply to death penalty cases, even though it's not in a death penalty case. Which, fair enough. That's his prerogative. It's up to the judge to determine the scope of testimony. It's an abuse of discretion standard unless it's legally required, in which case the right standard would be, clear error of law. So she says, okay, here's some guidelines that apply to the death penalty. This isn't a death penalty case, so they're not required. Okay, but I'm going to use them anyway. Okay, so the judge is basically constraining the scope of the testimony using what he thinks are guidelines, and he announced it and he's applying it fairly. So the correct standard seems like abuse of discretion. Okay, and so that's the way the judge wants to roll. Fair enough. I mean, that's the way the judge wants to roll. That's the way the judge wants to roll. Judges get to control their testimony, their courtroom. They get to control witnesses. They get to do those kind of things. So fair enough.
And demonstrated. The worst part of it is that there's a 6-year-old that will grow up not knowing the man that we've known.
The judge is not afraid to judge. I appreciate that. Yeah, the judge told you the rule in advance, and he was very clear about the rule in advance. And he even took the time to say, hey, state, have you told the victims about this rule? Because this is the rule, and I've told you in advance this is the rule, and I'm actually going to do it. And then the judge actually does it. That's nice, right? That's nice for a change. The judge made a decision. He's like, here's the rule. Everyone's aware of the rule. And then they're like, they're not following the rule. And he's like, you're right, they're not. He's actually judging. It's amazing. Wow. That being said, however, I still think it's questionable at best. The defense is actually using the objections. They don't have to object. And I think it's questionable at best that they're objecting. I mean, it's certainly their prerogative. They're not wrong. But I mean, read the room a little bit. Damn.
The loss to this country and to the Western world of the brain, the smarts, the ability to problem solve in a way no one thought possible.
The judge isn't being proper here. The objections will not be useful in appeal because the objections are only beneficial to the defense. It's not a basis to object for the defense. It's a constraint on the state, not really on the defense. So it's not really a basis to appeal. Not for the defense, it's not. It's like, I really wish they had said more insulting things. Your Honor, your Court of Appeals, the problem was they weren't allowed to say even more insulting things against me in their victim impact statements. Yeah, that appeal doesn't work. That appeal doesn't work. But, shine on, Crazy Diamond.
Was something unique to Doug Benefield that was stolen from us, our family, his daughters, and the world. And I'm sorry that we're here. But that's the theft that's happened. That's the loss.
The objections will be used to appeal the sentence? No, they won't.
Could possibly.
I'm going to say this again because either you didn't understand me the first time, or the constraint is only a benefit to the defense. It's not really a basis for the defense to object because the error would be that the victims weren't allowed to make even broader statements than they were allowed. It's the defense who's objecting to the statements. The defense doesn't have to object. It's the defense who is objecting, and the judge is sustaining the defense's objection. How could it possibly be a basis to appeal? First of all, it only benefits the defense. Second of all, it's the defense who's asking for it. It's the defense's motion. So how could it possibly be a basis to appeal? It doesn't make any sense. So no, it's not a basis to appeal the sentence. It doesn't make any sense that it's a basis to appeal. No.
Be replaced. I personally, our family asks for a minimum.
And even if that wasn't a problem, what is so first of all, it's the defense asking for it. And second of all, I really wish they had been able to say even more mean things about me. I really wish they had been able to say these things against me. I really wish the statements had been broader. The statements against me, I wish they had been allowed to say even more things against me. What kind of objection is that? What kind of appeal is this? It doesn't work.
Of 25 years and the maximum possible of 30 years, Your Honor, due to the grievous loss of killing Doug Benefield by Ashley Benefield. Thank you, Your Honor.
Yeah, that doesn't make sense.
And I believe
Steve?
lastly, we have Eva Benefield.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Yeah.
All right, yes, ma'am, if you could please introduce yourself to the court and tell me what you want me to know.
I'm Eva Benefield, Doug's daughter.
She's wearing a fish pendant.
When my dad moved from Charleston to Florida, I was a little over 18 years old and preparing to go to college. He was on the road a lot, and I would occasionally see him when he passed through South Carolina on his way up north. Although I did not get to see him as much as I liked, he was always a text or a phone call away. After my mom died, my dad knew it was important for him to answer the phone as soon as he could. He was out of town when she passed, and I had been trying to call and text her after school for what felt like hours of waiting in the carpool pickup line. After finding her later that evening, any time my dad didn't answer, it sent me into a spiral. My brain automatically went to the worst possible outcome, thinking something terrible happened. My dad's colleagues can attest to the fact that even if he was in the most important meeting of his life, when I called, he would step out immediately and let me know that he was in a meeting and he would call me back as soon as possible. My dad usually woke up in the very early hours of the day. The first thing he sent me was always a Bible verse followed by, "Good morning, pumpkin." This was his way of letting me know that when he was awake and he was available for me to call him when I woke up and tell him about the day I had ahead of me. The morning of September 28th, I woke up to no messages from my dad. I wasn't alarmed quite yet. Sometimes he rushed to the gym or had to immediately get to his computer for work. As the morning droned on, I anxiously awaited a phone call or a text message from him. Around lunchtime, I began Googling about traffic accidents in Sarasota, Florida. My friends told me, I told my friends I was worried, and they let me know I had nothing to worry about, that my anxiety-ridden brain was just flocking to the worst possible outcome. 9:24 a.m. Good morning. 10:42. Hello. 10:43. You're kind of scaring me. 11:20. You should definitely text me so I know you're okay. 11:48. I'm about to text Ashley. 11:49. Just kidding, I don't have her number. 12:03. This is freaking me out. 12:55. Please, please, please answer. 12:56. Great, now my texts aren't going through. 12:57. I hate this so much. It was about an hour later that I received a phone call from my uncles that my dad had been shot the night before. Is he okay? I asked. My uncle responded with a hesitant no. My next question before hanging up the phone was, she did it, didn't she? Ashley, since the day you shot my father, I've only had one question to ask you. Why? Why did you end my dad's life knowing he was my only living parent and the only person I could confide in and count on for everything I needed as I turned into a young adult? Why did you willingly take away your daughter's father, knowing the consequences of your actions would leave her without either parent to help her navigate through her own life? You somehow managed to orphan not one, but two young girls. Unlike Emerson, I am fortunate enough to have known my dad for a full 19 years before you ended his life. He taught me how to paint. He attended every extracurricular activity I had. He took me to dinner on Valentine's Day. He drove almost an hour out of his way every day to drop coffee off in the school office for me and my friends. When he was in too much pain to surf with me, he would sit under an umbrella on the beach all day during the hottest months of the year. He would cut fresh flowers from the garden every morning before my mom woke up and left them on her bedside table. While I ran in the mornings before school, he cooked breakfast so it would be ready on the table when I got home. Every Saturday, we made oatmeal cookies together. Every Sunday, we would go to church and get a coffee after. When you moved into my childhood home, I watched my dad fix the door frame with a crack in it from where the neighbor had to knock the door down to get into the house after my mom died. I watched my dad paint over every memory in every corner of that house, change the furniture, rid the house of every bit of my mom that was left so you could enjoy life without remnants of my dad's late wife and soulmate. I had to come home from school to see you barely clothed, sitting on the countertops my mom used to cook our family dinner on. I had to live in a house stripped of memories I still cling to so I can remember the happy childhood my parents gave me. Not only did you make my home nothing more than a house with 4 empty walls and a roof while I was grieving the loss of my mother, you tried to bring my mother's sweet spirit into your soulless world by spreading lies that she was killed by my own dad. You got medical records pulled, and you were moments away from getting her removed from her own grave.
Apologize for interrupting. The same objection. I don't think attacking the defendant is appropriate victim impact statement.
Sustained.
When you left my dad the first time, I watched his face as he read the letter you left on the bed for him. The house was quiet that day, and while I felt sorry for my dad because I saw the pain in his eyes, I was secretly excited to have my dad back. Those few months that he received nothing but radio silence from you, I was able to finally regain the relationship we once had. Things finally felt normal again. Easter weekend of 2018, my dad insisted that I drove to Florida with him so I could enjoy Easter Sunday with my half-sister. The night before Easter, you and Alicia pulled me aside before dinner to try and convince me that my dad was a monster, that he killed my mother, that he was evil and I was unsafe. The next morning before you brought Emerson over to open Easter baskets, my dad could tell something was off.
Judge, same objection.
I can see two ways this could go. It could come back around. I don't know where it's going. I don't know what the next statements are. If the next statements contrast that with with evidence designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death, then I'll overrule the objection. If not, I'll sustain.
While I feel
I've never
deeply
really
sorry for
seen
everyone who was affected by these
objections in a
last few
victim
hurricanes
impact
this year,
statement.
They couldn't help but remind me of the time my dad drove 8 hours through a hurricane to come help you board the house you lived in at the time. My dad was the opposite of what
Does
you
the
have
defense
attempted
think
to
these
portray him
objections
as.
are helping?
Doug Benefield was kind to a
I don't
fault.
know, man.
He was smart, he was strong, and most importantly, he was generous. His generosity is what got him killed. December 2nd, 2014, 10 years ago yesterday, my dad was out of town when I found my mother dead on the floor at 14 years old. Her funeral was the first and only time I saw my dad cry. Not even a year later, he met you during what I imagined to be a very lonely part of his life. You decided to put on your biggest act of your career and pretend to be everything he needed to fill a void. I watched
Judge,
him.
same objection. Again, apologize for interrupting.
And Judge, I think she can talk about her dad and how he took this in and was kind. Even,
If that's where it's going, but as I've said multiple times, and as I'm pretty sure I confirmed before we started, that the state had gone over with its witnesses,
Yes.
the nature and extent of an
I
appropriate
just have
victim
a
impact.
difference of opinion as to what they're allowed to say, Judge. So it's
I'm
difficult
going
for
by the
me
Florida
to-
law,
For death penalty cases.
and I said that it's appropriate. I think they're good guidelines.
Well, yeah, I mean, the judge has an opinion. He wants to follow the guidelines for the death penalty case. And you're like, but those aren't the guidelines. But the judge is like, but they're the guidelines I'm using. And so, and I confirm that you are going to do that because those are the guidelines I'm doing. And it's like, well, yeah, judge is judging, that's fine. Defense is being a bitch, though.
I watched him bend over backwards for your every need. For years, he gave you everything he had, time and time again, trying to show you, Emerson and Alicia, nothing but love. He wanted nothing more to show you what true acts of love are. You took advantage of his willingness to give, and he gave you his
He
life.
certainly can.
After my dad passed, there were a lot of sleepless nights contemplating if my life was even worth living. I had no financial
Nothing
help,
says he
no parental
can't.
guidance, and no will to live. The idea of ending my own life was oddly gave me some sort of satisfaction knowing you would have to live the rest of yours with blood of 2 Benefields on your hands. Shortly after those dark days, I realized I would selfishly be doing my parents a disgrace to not live every day to its fullest as they had taught me before they passed. I also realized that not only would you not care if I was dead, it would probably be beneficial to you. I'm the only one who can speak truthfully on behalf of my father and fight for his justice. While the grief of my parents will always live within me, what hurts me the most is not the thought of not having my dad anymore, because I will always have him around in spirit as I continue to implement the lessons he taught me during my adult years. What breaks my heart the most is thinking about how he found you at such a vulnerable part of his life, gave you everything you asked for. After you shot him while he was unarmed, he laid there bleeding out, unable to speak or to breathe, completely helpless and dying alone.
All right, thank you, ma'am.
Thank you.
State, did you have any other victim impact statements?
No, Judge, that's it.
All right. Any other evidence that you were going to submit? Any letters, documents, anything?
No.
Okay. Rebuttal evidence or statements? Or just argument?
I have some argument to the court.
Okay, so I'm going to consider the evidentiary portion closed. We're going to begin the closing arguments. And so we're going to go defense first, then I'll go to the state, then I'll come back to the defense for rebuttal.
You're not going to ask explicitly if the defendant wants to make an allocation?
Before
That's a bit of an error.
addressing my closing remarks, I want to address the downward departure specifically and make two comments. One is to the victim's status. I want the court to recall the independent evidence that was adduced at trial, for the moment excluding Ms. Benefield's testimony. Specifically, Doug Benefield's admissions establishing a prior history of domestic violence. There's obviously a dispute, and it depends to a great extent through whose lens Doug Benefield is viewed. Perhaps the truth is best found in the testimony of independent witnesses, because family who love Doug Benefield sees him in one light, and the independent witnesses see him in a different light. So we not only have the admissions that did not come into evidence at trial, but I know that the court is aware of, and of course, this being a sentencing hearing, the formal rules of evidence are not applicable. And in those admissions, Doug Benefield not only admitted to various acts of domestic violence, I don't think an act such as firing a firearm in the kitchen of a home into the ceiling, specifically acknowledging that you did it to intimidate your wife into stopping to speak, is the kind of act that one is able to say, gee, you know, in hindsight, I've thought about it and I was wrong. Forgive me. There are certain acts that manifest a much deeper problem. And those of us that are members of society who have never so much as contemplated such an act realize that it speaks to a much deeper problem. So we not only have Doug Benefield's admissions under oath of these various domestic violence incidents, but we have him violating the South Carolina court's domestic violence injunction, his efforts to purchase the house behind Ashley Benefield's while the domestic violence injunction was in full force and effect, placing a tracker on Miss Benefield's car, being caught by a neighbor at night lurking in the backyard, and the independent expert testimony from not only Dr. Jason Quintal, describing Doug Benefield as super controlling, a real alpha male, and intimidating, quote unquote, as well as Bruce Ferris, who said that Doug Benefield was a classic abuser, who showed all the textbook characteristics. And then, of course, the text message from his deceased wife, Renee, clearly explaining about being physically abused on their honeymoon. I think that the facts establish, for purposes of a downward departure, Douglas Benefield's contribution to this incident and the threat that he posed to Ashley Benefield. And because of that, I believe that the defense has clearly met their burden by a preponderance of establishing that Doug Benefield was a willing participant in the conduct that led to this shooting. The second basis, Judge White, with respect to departure, would be the extreme duress that Ashley Benefield was under at the time of the shooting. The expert testimony the court heard from today from Dr. Barbara Russell speaks to that. And the only testimony that is in the record that actually was put forth to recount the events of that date was by Ashley Benefield. There is no other testimony. And in that testimony, she clearly recounted not only the body checks that Doug Benefield delivered to her that day, the cardboard box assault, the false imprisonment when she tried to leave the house, the slap. It was very clear from the letter that Ms. Benefield left for Doug Benefield that she feared for not only her own safety, but the safety of her unborn child. She articulated that quite clearly in a letter written 3 years before this incident. That's either an incredibly prescient false flag that was planted or the truth. The truth of a woman who was scared. The truth of a woman who, despite what the court has heard about Doug Benefield from the family who loved him, obviously had a much deeper problem. I believe that together with those incidents, Doug Benefield's admission and the confrontation on that day, Ashley Benefield was clearly, as Dr. Barbara Russell explained, acting under extreme duress. And I believe that the burden as to that basis for departure was carried as well. With respect to closing remarks on behalf of Ms. Benefield, Your Honor.
I think the sentence is likely to be on the lighter side.
Very, very clear that despite the exposure that Ms. Benefield faces to the court's potential sanction, she adamantly maintains her innocence, that she acted out of fear for her personal safety and shot helpless Benefield in self-defense. The sound discretion of the trial court in ruling upon the admissibility of various evidence, that's the phrase that the appellate courts use to describe the authority of the trial judge.
Abuse of discretion.
It's the object of that discretion to ensure that evidence which comes before the jury is reliable and trustworthy, or is that discretion designed to allow the trial court to manipulate the outcome of a trial to achieve a particular result? Jurors are told in every trial that there are two judges, the court, who is the judge of the facts of the law, and the jurors, who are the judges of the facts.
Yeah.
But what if facts, essential facts, are kept from the jury? What if the court, rather than using its discretion to ensure the evidence is reliable and trustworthy, instead uses its discretion to undermine the effectiveness of the defense?
Ooh, I don't know. I mean, you're banking a lot on, errors that were made in the trial, man. But right now you're insulting the court. You're like, okay, yeah, the standard is abuse of discretion, and you fucked it up, Your Honor. I don't know, man. I'm not sure this is the way to win friends and influence people. Now, he might be right, I guess, but you're banking everything on that appeal because you're pissing off the judge, I would imagine. Okay. All right.
Guard their efforts to water down the impact of their position. Respectfully, that is precisely what we believe occurred here. Ms. Benefield was deprived of a fair trial, Judge White. Despite that, she was still acquitted of murder.
Yes.
Further, we believe that had the facts been put before the jury, Ms. Benefield would have been found not guilty. What then is our basis for that proposition? Let's start, if we can, with the court's order denying our stand your ground motion.
Judge, I'm going to object to going over the court's rulings being wrong. I don't really understand the significance of this in a sentencing. These are past orders, and we don't need to rehash them if you disagree that they're correct.
All right,
Yeah, I
what's your
agree.
objection? What, improper argument?
Improper argument.
Sir?
I believe, Your Honor, this is a sentencing under the rules of criminal procedure. We have an absolute right to address the court. I deliver my remarks not out of disrespect, but of counsel for a woman who faces 30 years in prison for a crime that she adamantly maintains she did not commit.
Overruled.
Thank you.
Yeah. I mean,
In
I
the
don't know,
court's
man.
order, the court
Okay.
stated that this was instead the culmination of a lengthy, concerted effort by the...
I disagree with the judge's ruling there. Sustained would have been better. Like, look, we've fought over these issues already. Like, if you want to appeal on the basis that I made errors already, then, appeal. But we're here for sentencing at this point. So challenging the decisions of the court as to the admissibility of evidence, like, no, you can't do that right now. I mean, yeah. And you've even set up like what the right standard is abuse of discretion. So you're going to have a tough time on the on appeal. Now, I mean, but okay. Take it up with the Court of Appeals. That's what they're for. But I'm not sure why you're mentioning it now.
Defendant to eliminate the victim from her life and the life of their child. When the defendant's efforts to enlist the assistance of law enforcement, Child Protective Services, and the judicial system failed, she took matters into her own hands, as she told Dr. Broder she would. So what happens with that statement is that we take the deposition of Dr. Broder, and I asked Dr. Broder in that deposition, now that would make your statement incorrect, would it not? And I'm specifically referring to Dr. Broder's statement that Ashley told him she was going to have to take matters into her own hands, thereby insinuating she shot Doug.
Yeah.
And Dr. Broder's response was, in terms of that quote from the report, yes. I then asked, so based on that, those would be your words, not Ms. Benefield's, correct? And Dr. Broder answered, in the testimony, yes. Question, all right. And your comment referred to Ms. Benefield's decision to seek help from the Maryland authorities, did it not? Answer, that was her plan, yes. What's troubling is that Dr. Broder's testimony at the Stand Your Ground hearing then was at best mistaken and at worst a false implication to mislead this court. And the court bought it because it said, just as she told Dr. Broder she would. So we felt that the Stand Your Ground decision was based upon a mistaken statement by Dr. Broder under the best of circumstances. Now, what are the other issues that we feel deprived Ms. Benefield of a fair trial and precluded her from putting her best case, her best defense before the jury? There were a number of evidentiary rulings that
You're working on that appeal as we speak, aren't we?
specifically, Detective Warren's conclusion that he reached less than 45 minutes after the dispatch call came to him about the shooting, that the matter
Yeah,
was a
that's
murder
that's what I'm
as
saying. This is
opposed
stuff
to a
for
homicide.
appeal. As a trial judge, I would not allow this. As a trial judge, I would not allow this. Look, friend, we obviously had the hearing. We had the Stand Your Ground hearing. We obviously had these issues. We had the trial. We had the trial with the admissibility of evidence. Okay? Now, did I make a mistake as a judge? Maybe, but tell the Court of Appeals about it. Right? I mean, I would not allow this. I'm not going to let you relitigate the trial in the sentencing. Tell me about the factors, presuming that she's guilty. Tell me about the factors, because she is, because the jury found her guilty. Tell me about the factors that I should sentence her based on. Not, oh wait, she's actually innocent this entire time. It's like this is yeah, this doesn't work for me, man. This would not work for me as a judge. I'd be like, this is improper argument. It's if you really think I messed up the Stand Your Ground hearing, if you really think I made a mistake with the admissibility of evidence, tell the Court of Appeals about it. That's not what I'm here for right now.
Homicide. The court may recall that the lieutenant in that department testified that you can't make a decision about a homicide immediately. It takes time. You must investigate it. They could have applied for the warrant. Detective Warren could have applied for the warrant and secured it just as well by submitting that the potential crime that occurred was a homicide. Instead, within 45 minutes, he described it as a murder. The significance of that is that it shows his state of mind and whether or not this was always an incident and a bias towards Doug Benefield that they embraced. Doug.
And by the way, I wasn't there for every hearing. I don't know. Maybe that's one of the reasons that Melanie's chat is so pissed. Maybe they were there for all the hearings and they really think the judge pooched it. Maybe they really think that the judge failed. Because I just stopped in at Ashley's testimony. Really, that was my exposure to Ashley's testimony. Like, I don't believe her. But, because she's the only one there at the moment of truth, as it were. But maybe they just think that, there's been miscarriages of justice throughout. Maybe they're right. Maybe there have been miscarriages of justice. Maybe the judge made a mistake. Maybe the evidentiary picture is wrong. Maybe, it would, if this evidence were brought in, it would change our assessment of the probabilities of what happened in the moment of truth. So maybe there's some truth to that. Of course, it doesn't necessarily change the ultimate conclusion, but it does change perhaps the probabilities and assessment, particularly on a beyond a reasonable doubt standard. But I digress.
And from everything that the court has heard from his family who loved him, he was very skilled at manipulation and was easily able to cuddle up with the detectives, and they liked him. And because they liked him, it influenced the objectivity of their approach to the case. We were never given the opportunity to establish that. Secondly, the email exchange between Detective Warren and Ms. O'Donnell, where they discussed and participated in representing different facts for the purpose of securing an arrest warrant. Again, it went to their credibility. We were not entitled to get that in front of the jurors. The lead detective's perception, in addition to calling this a murder within 45 minutes, that, quote, all killings are murders and all who kill are murderers. This is the mentality of the lead homicide detective in the accusation against Ms. Benefield. We were precluded from demonstrating that before this jury to be able to argue with credibility that Ashley Benefield never had a chance. They decided, Detective Warren decided, within 45 minutes this was a murder, and then he did everything from that point on to support his position. It went to the heart of this detective's credibility. The admissions by Douglas Benefield in his deposition of July 17, 2018, somehow the court concluded that that was not a statement against interest, which we bitterly disagreed with and still do. But more importantly, it was the integrity of the statement of the victim under oath that we were never able to put before this panel for them to make their own independent judgment. It's one thing for me on behalf of Ms. Benefield to be able
again,
to
these arguments may be right. It just feels like this is the wrong time and the wrong place. This feels like, tell the Court of Appeals about it. Tell the Court of Appeals about it. The judge made a mistake. He excluded evidence he wasn't supposed to exclude. The jury didn't have the right picture, Your Honor. It's like, yeah, but the judge has made a decision. And the judge has made, why are we bringing this up in sentencing? So I'm not saying these arguments are wrong. I am saying it's the wrong time. It's the wrong time, man. The right time was in the past when we had the argument in the first place, and in the future before the Court of Appeals. The proper place for the argument was in the past and in the future, but not in the present. So yeah, I don't like this. I don't like this. I'd be bad as the judge. I'd be bad.
To the jurors that he made this statement. It's quite another thing for them to hear it out of his own mouth, and in particular, for them to hear that his explanation for it was that he blamed it on Ashley. This is classic abuser perception, that it was Ashley's fault because she would not stop speaking, and it was her fault that made him fire this gun into the ceiling of their home.
Shut so hard.
It deprived the jury of clearly the most persuasive and compelling evidence
that
this
is the
defense
sentencing
could have put
phase
before them. That same strategy was employed by the court in keeping out the letter that Ashley Benefield wrote and left for Doug Benefield on September 17, 2018. I don't know that I've ever had an instance of a more specific state of mind exception to the hearsay rule than that letter. There is no way that anyone, I would submit, could articulate with the same decisive and persuasive influence on the jurors that letter, seeing it, feeling it, reading it, would have accomplished had it gone to the jurors.
We're relitigating
In that
evidentiary
letter,
decisions right now.
Ms. Benefield not only stated how deathly afraid
Why
she
are
was
we relitigating
for
evidentiary
what
decisions,
took her child,
Chad?
but she also listed all the financial problems that beset them, and in particular Doug Benefield, which would
What's the
have
ju-
addressed
what are you
the
hoping
unspoken
for? Are you doing a motion for a new
knee-jerk
trial,
reaction
basically?
that
Is that what you're
constantly
doing?
arises from the perception
You're doing a
that
motion for a
Ms.
new trial?
Benefield was a gold digger who married somebody.
I mean,
who
you
was
didn't.
only
It didn't
going to
sound
be
like
able
that
to
was
provide
what was
for her.
happening. I heard downward departure. I didn't hear motion for a new trial, but maybe we're doing a motion for a new trial in the middle of sentencing. Is that what we're doing? Let me tell you all the ways you fucked up, Judge. I don't know. 'Cause it sounds suspiciously like that's what we're doing. The judge said, "I'm going to hear you on downward departure," and
I think it would have
what
been
I'm getting
significant
is,
for the
here's
jurors
our
to
motion
hear
for a
from
new
Bruce
trial.
Ferris that this perception of domestic violence and lack of appreciation for it infects our institutions as well as the courts themselves. And I think Bruce Ferris was extremely qualified to provide such testimony, given his background as an active deputy sheriff who worked and specialized in domestic violence and was in court time and time and time again.
What? Yeah, I mean, all this is on the record.
had
It
an
has to be. I mean, if it's not already on the record, the defense fucked up hard, right? If this is the first time that this is being put on the record, holy shit. So I'm going to go on the presumption it's not the first time it's put on the record. I'm going to go on the presumption that all this is already on the record and these issues are preserved. We don't need to hear it again. And it's like, okay.
Since where both parties agreed and the court approved for a cutoff for motions, despite the fact that we both agreed.
The state did object.
Signed a written stipulation, both myself and Ms. O'Donnell and the court. The state still moved for a Daubert
Yeah, they didn't
hearing.
object. The defense
After the
bringing it up
court
now is
suggested
going to be problematic. You have to make
after
contemporaneous
the deadline
objections.
for such motions was closed.
So if you didn't make the
court
objections
allowed the
before, you're
state to do
fucked.
it,
And if you did make
reopened
the
it.
objections before, you don't really
We
need
had
to
the
do it
hearing.
again now.
The court still allowed Bruce Ferris to testify. When the state sought to introduce the video of Douglas Benefield and Miss Benefield and Emerson Benefield and Alicia at the restaurant, upon the defense objection, the court, to the state's surprise, sustained the objection. The state, recognizing how critical that evidence was to their case, looked to the court for help, and it came in a suggestion from the court that perhaps they may try to introduce that evidence under the silent witness theory. Inexplicably, another piece of evidence that was kept from the jury was the DNA evidence. Despite having filed a notice of disclosure of intent to introduce business records declaration, the court prohibited us from introducing the DNA report, which showed that Douglas Benefield's DNA was in fact found on Ashley Benefield's arm and hand, which would have corroborated Miss Benefield's testimony that she initially tried to flee her home, only to have Douglas Benefield grab her, spin her around, put his own back to the door of the home, and refuse to allow her.
Husband's DNA found on wife's skin. Film at 11, though. I mean,
At trial, the court allowed substantial hearsay to come in through the testimony of Stephanie Murphy. We objected and asked for an instruction. The court agreed that an instruction, a limiting instruction, would be appropriate, yet the court never gave such an instruction. And the reason
the
court
judge
gave
can
for not
absolutely
giving the
stop this sua
instruction
sponte.
was that
The
state
judge
and the
100%
defense were
can
unable
stop
to
this sua
agree
sponte.
to the language.
The judge
court
just
should
sitting
have
there like a
fashioned an
dolt.
instruction and given it. The court allowed Detective Christopher Gillen to testify to his various interactions with Miss Benefield, and in particular, Miss Benefield's response. Yet, Your Honor, would not allow the defense to call Samara Sweet, who was the Assistant State Attorney for the Manatee County State Attorney's Office, assigned to the case that Detective Gillum testified about, to rebut what Detective Gillum said. Because Samantha Sweet would have said, when she left the office, she fully expected that case,
Maybe it'll be an interesting
specifically
appeal.
the violation of the South Carolina domestic violence
Note
injunction. by
to
Douglas
chat when
Benefield
when the
would be
briefs
charged.
inevitably get filed in the appeal. Maybe we'll read them. That could be
Additionally,
fun.
the court made some non-evidentiary decisions which we felt had a profound impact on retarding the effectiveness
Then on civil
of the
can play
defense's
appellate
case.
judge and try to figure out whether or not the
The
judge
court
made a
actually
mistake.
quashed the defendant's subpoena to Judge Moreland's judicial assistant and forced the defense to pit Ms. Benefield's former family law attorney against the state's star witness and Doug Benefield's former family law attorney, Stephanie Murphy. We have a Sixth Amendment absolute constitutional right to compel the attendance of witnesses.
Yes.
On behalf of Ms. Benefield, using my judgment and my experience, I felt that Judge Moreland's JA had no dog in this fight. There was no one that would have been more credible to explain to the jurors that the state's theory, the entire theory of prosecution, that Ashley Benefield killed Douglas Benefield because the Broder report was scheduled to be released, was absolutely false, because the JA would have testified that that report was not set for release. There was no date that had been given for that release. Somehow, the court decided that we, the defense, could establish that through a different witness rather than the JA. Respectfully, that is not Your Honor's decision. That was my decision, and it should have been honored, because as I stand here today, I felt and still feel that that would have been the most persuasive evidence to show the jury that Stephanie Murphy's testimony was not worthy of belief. The court allowed, in closing argument, the state to allege that Doug Benefield filed for sole custody of Eva Benefield on May 4th. And that's just factually inaccurate. The fact of the matter was it was Ashley Benefield who filed for sole custody of Eva Benefield. Yet, our objection was overruled.
During closing?
Sir?
During closing? You
Yes.
objected during closing?
Yes.
No.
Additionally,
Excuse me? Can you point to me in the transcript where that is?
I'm not prepared to do that now, but as the court knows, the transcript is readily available. What the court did do, however, was, despite the state arguing that Doug Benefield was not facing Ashley Benefield at the time of the shooting, even though that was what their own medical examiner testified to, when I characterize the state's argument as ridiculous, the court felt that was sufficient to sustain an objection. The problem I had with that, and still do, is that one, the court is determining what witnesses are most effective for the defense, and two, the court is precluding me, on behalf of my client, from sharing with the jurors my perception of the state's theory of prosecution. Additionally, and this was over the strenuous objection of the defense,
During closing?
this was now during deliberations.
Okay, all right.
The jurors came back with their first question, asking specifically whether Dr. Jason Quintal reached the conclusions about Doug Benefield himself, or whether or not that was something, the characterization was something in the materials that Dr. Quintal had read. At that point, I thought it was pretty easily addressed by simply having Dr. Quintal's testimony read back to the jurors. Because make no mistake, I asked Dr. Quintal, and Dr. Quintal stated that he concluded his diagnosis of Doug Benefield was that he was,
We're
quote,
redoing the entire
super
trial
controlling, a real
during
alpha
sentencing
male,
right
as
now.
in, don't even look at her, she's mine. And to my surprise, the court would not allow a readback of Dr. Quintal's testimony. Now, at that point, we can only speculate as to what the divisions were during the deliberations. But what we do know is that the jurors wanted to know, was this an independent diagnosis that this expert in trauma had reached on his own or not? The court deprived us of that opportunity by not telling the jurors that they were entitled to a readback if they wanted it. That's all I asked, is that the court tell them, if you have questions, we can have Dr. Cantel's testimony read back to you. The court refused to do so. When the jurors came in and announced at 10:30 p.m. that they were hung, we begged Your Honor to send them home for the evening. There was no reason to keep them. There was nothing pending that required a verdict that night.
There's nothing that precludes it either.
The jurors had been there more than 12 hours. Respectfully, again, the defense
Yeah, Lisa,
felt
I think
that
he's
it was the
mischaracterizing
court's
many of the
intent
things
to
too.
drive a result that evening.
It's just the wrong time, wrong
It was
place, and I think he is
at Ms.
mischaracterizing things.
Benefield's expense.
Some of these things, I'm like, I don't think that's right.
So, to sum up, Your Honor, and to close, I can only tell the court that it was a very heated trial. I think the court, for whatever reasons, made an initial judgment and never changed its position.
Ooh, I don't know, man. That's you just told the judge that he made an initial judgment. He prejudged the case. Ooh, okay. All right, well.
And as a result, our efforts were not
Big balls.
what
I mean,
they
that
could
is
have
for
been.
sure. I agree.
And in
100% big
particular,
balls.
that we believe would have influenced the outcome, especially because there was not a conviction for the charged offense. The jurors obviously thought something happened in that house on that day. Something occurred in the past that affected Miss Benefield's judgment. What they did conclude, which we're forced to respect at this point, is that the judgment that Ashley Benefield exercised on that day was faulty, and she did not have to shoot him. But make no mistake, they acquitted her of murder. So what we're left with is a woman who all her life
All right.
has not
Things happened in the YSL trial while we've been doing this. So briefly diverting our attention to the YSL trial. It looks like it's over finally, thank God. On the fourth day of deliberations, Tuesday, today, the jury in the YSL RICO case determined that the final two remaining defendants were almost entirely not guilty. DeMonte Kendrick was found not guilty on all the counts against him, and Shannon Sitwell was found guilty only on one count of possession of a firearm by a convicted felon, which is to say they were not found guilty of the murders. So good for them. Stitwell was sentenced in court and will leave a free man. He was given 10 years, only 2 to serve in jail and is credited with time served. Fair enough. The remainder of the sentence is probation. And the YSL case is finally over. Well, no, not really, because there's still some other defendants that are waiting to be tried in a separate case. This phase of the YSL case is over. We either got guilty pleas or plea bargains or not guilties. And only one guilty that no one will appeal. So this phase of the YSL case is over. Somehow, some way, it has come to an end. I don't even believe it myself, but apparently it's come to an end. Moving on.
Anything other than a good citizen, and who in the court's own words, had the system failed her. She constantly made report after report to the authorities who never took any action. You can't help but wonder what would have been the outcome of these events had Doug Benefield been charged with a violation of the South Carolina restraining order. Would they have ended up in this position? I also don't think the court can discount the acts of domestic violence, the independent acts, the acts that are established by Doug Benefield's own admissions, and in particular, the justification that he gives for those acts. So if you conclude that Ms. Benefield was subject to abuse by Doug Benefield, then that has to affect the sentencing that the court imposes. If you conclude that she was not affected by the prior acts, the trustworthiness of which is hard to dispute given his own admissions, then I think the court turns a blind eye to independent evidence establishing that he was abusive. We know the one thing that Dr. Broder did get right was he spoke and concluded about what a wonderful mother Ashley Benefield was. I think it would be beyond dispute to say that this was an unusual act, an aberration from a woman who has no past whatsoever. There's nothing that can replace the loss of Doug Benefield's life. There's nothing that anyone's going to say to the Benefield family that's going to make them feel any better than they feel now. What I can only remind the court is that the independent evidence from Doug Benefield's side, the family thinks only the best. From Ashley Benefield's side, all the supporters think only the worst. We're compelled to look to the independent perception of Doug Benefield. And even were the court to discount Dr. Russell's testimony, that still leaves Bruce Ferris and Dr. Quintal. And that testimony establishes that Doug Benefield had a deep-seated issue with abuse. It doesn't mean that the family didn't love him, but he would not be the first person that loved ones don't recognize has an issue. And if Ms. Benefield was subjected to abuse, then that's something that Your Honor must take into account in applying an equitable sentence. I hope the court is strong enough to do just that. Thank you.
All right, before I go to the state, I do have a couple of questions. Sir, in your memo, this is regarding downward departure bases. I'm starting with statutory.
Yes.
Under 921.0026 subsection 2.
Yes.
In your written documents and today, you focused on F, victim was initiator, willing participant, aggressor, or provoker of the incident, and G, defendant acted under extreme duress or under the domination of another person. However, you also elicited testimony from Dr. Russell today regarding her diagnosis of Ms. Benefield with PTSD, explaining the genesis of that and how it could affect her. Are you seeking a downward departure under D as well?
It was not my intention to seek any other basis other than what was included in my written sentencing memoranda, but as the court knows, that was filed in advance because I had another trial out of town that I had to attend to. If the court wants to accept that as a potential basis, as well as aberrant act, that's fine. We would be quite content. Either way, our objective is that a downward departure would be appropriate. As the court knows, it comes in the form of two questions. One, is it legally available? And two, is the sound discretion of Your Honor? Should you? That's up to the court. I believe we've presented the court with sufficient evidence for all four bases, but my written memoranda only includes two.
All right, well, now, which one's the fourth?
The fourth would be aberrant incident, aberrant behavior.
Oh, isolated incident under J? All right, so the reason I ask is it's not uncommon during a sentencing hearing for me to hear testimony or evidence presented by the defense that is intended for mitigation, but actually goes to one of the downward departures. That's why I want to clarify.
Yes, thank you.
All right, that's for the statutory bases D, F, G, and J. There's also non-statutory bases. In reading your downward departure or your sentencing memo, and today, you've spent a number of pages in the memo, and then a significant time today of your argument on individual and cumulative errors at the trial court level.
Yes, sir.
Are you intending that to be considered as a non-statutory basis for a downward departure?
I can't speak for Your Honor. I can only serve up what I believe contributed to us.
He wasn't
having
asking you to
less than
speak for him.
effective-
He was asking if you wanted to argue for a basis other than what the statute provided for. It's like, well, I'm not speaking for Your Honor. It's like, but I'm asking you. Do you want to argue for something beyond what the statute allows for, or explicitly contemplates, rather, would be the better way of putting it? So that's a weird answer to the question to me. Again, like the open answer would seem to be the way to go. It's like, well, that wasn't really my intention, Your Honor, but if you wish to consider that as a non-statutory factor, then we'd certainly welcome that as well, Your Honor. That'd be fine too, because you don't really care how you win, right? Winning is winning. So I think his answer on the other thing was fine, right? It's like, oh, I only raised these two bases, but if Your Honor sees reasons beyond that in these other things, that would be fine too, because I still win. And then he's like, well, in addition to the 4, how about this mysterious mystery box? It seems like the same answer, right? I really wasn't intending to argue the mysterious mystery box, but if Your Honor likes the mysterious mystery box, that's fine by me too, because I win. So I'm not really sure why he flips it on the judge like that. Seems like a strange answer.
Defense to these charges.
How does that affect the sentencing for today?
To the extent that the court felt that those incidents, and I say incidents rather than errors because that remains to be determined, and I respect the fact that we have a good faith dispute as to those incidents. But if the court decides that those incidents run, those rulings run to the court taking into account, well, maybe I did hold the reins a little too tight, and maybe as a result, the defense wasn't as effective as it could be, because after all, the court sits as the 7th juror. If you feel, knowing what some of the evidence was that did not make it to the panel for their consideration, yes, you would be entitled to embrace that as a basis for departure. And if the court chose to do that, we would be. And
that's fair too. To the extent that you're using it as mitigation or downward departure, that's different than, again, underlying liability. So like the rules of evidence, they said don't apply. I'm not sure whether or not that's strictly speaking true, but they're certainly broader than they are for a liability. In liability, they're a lot more constrained. For example, you can allow hearsay, and you definitely allow prior bad acts in sentencing because that's explicit. Like, how bad have you been in the past? Is going to be one of the things I'm definitely going to consider when it comes to your sentence, but not as to your underlying guilt. So if the judge is aware of things that were not admissible but could be used to mitigate or downward depart, then that's fair enough. I guess.
All right. That's what I wanted.
I still object to the expert though, because the expert was just flat out contradicting the jury. And that's different. Like, it wasn't like, here's some additional evidence. It's just like the jury is dumb. So I still object to the expert witness's testimony.
No, it'll be, say, footnote or parenthetically, certainly if someone can't suffer the slings and arrows and take the criticism, they certainly shouldn't be sitting in this seat. You have absolutely every right to disagree and appeal, and that's what I expect. It's part of the process. My question is this then. In my years, in researching and dealing with downward departures, I am not familiar with, I haven't seen any support, obviously because non-statutory bases are coming up through the common law, through court decisions where those matters have been recognized. The statute leaves it wide open, right? Any other bases that the court believes, so that's where we have this non-statutory downward departure bases. I am not familiar with individual or cumulative errors by the trial court being used or cited as a basis for a downward departure. So that's where I was ultimately going with all that. If it's intended to be a non-statutory downward departure, is there any support in the case law for that?
I'm not aware of that specifically.
Yeah, that would be odd.
But
the errors being a basis for downward departure would be very, very odd.
Of what I've had to say, and for
because it wouldn't be a basis for downward departure; it'd be a basis for a new trial.
The first basis of departure, the victim's conduct, the court can well take into account the admissions that were made by Douglas Benefield in
And the court
deposition.
took note, if the court took note of its own mistakes as a basis of downward departure, holy shit, you're writing your appeal for you on that one. Here's all the mistakes I made, but I'm only going to sentence you to 10 years as opposed to 20.
That does not.
So are we good
preclude
now?
Your Honor from embracing them.
Yeah, that
and
doesn't really work.
Reaching a determination for a downward departure.
Understood. All right, the next one was specific to G. I understand arguments and bases for D. I understand.
Downward
and appreciate
departure
your
is
argument
less than
for
the
F.
statute.
G,
Downward
however,
departure is less than the
G is
guidelines
acted under
range.
extreme duress or under the domination of another person. And I'm just going to phrase it as walking around knowledge of that statutory basis is it's generally a confederate or a co-conspirator or a principal to the offense, as opposed to that basis being used for the victim. The victim is the one that was causing the duress. That's where I think F comes in. The victim's the initiator, the aggressor. So do you have any case law or any law for me that G can also apply, the duress portion can be applied from the victim in the matter as opposed to a confederate, co-conspirator, or principal?
Yes, I don't have a case at hand for the court, but the distinction I will make for the court is let's not be too narrow and interpret that only as it relates to the incident itself. The point I tried to make through the testimony of Dr. Russell was that Ms. Benefield's state of mind on that day, given the prior history of domestic abuse, when in the company of Douglas Benefield, already created in her, because of this past trauma, extreme duress. And I understand the court's distinction, but I do not believe that there is any case law that says that the duress is limited to the moment of the act. I believe the duress can be present from prior occasions, and that was the point I wanted to establish for Your Honor.
I don't know if we're looking at a downward departure, but I do think we're definitely looking at something on the lower end of the range.
Final question. You had mentioned about Dr., and this was both in your memo and in your statements today, Dr. Broder's testimony where, I don't know what the best word is, I'll say walked back his testimony from the stand your ground hearing.
Yes, sir.
I'll just characterize it that way.
Fine.
And you talk about, so we had the stand your ground hearing. It was my understanding from the reading, because he wasn't impeached with any deposition testimony at the stand your ground hearing. The deposition you're talking about happened after the stand your ground hearing.
Correct.
Okay, all right. That was all my questions. Did you have any further statements you want to make in response to the questions I've asked?
No, other than, even though the deposition of Dr. Broder occurred after the testimony, it doesn't lessen what we perceive was the court's linchpin for the stand your ground order, which was tied to, at best, a mistaken statement, and at worst, a false statement to mislead the court.
I understand. Thank you. All right, State.
That was a very weird argued
I'm not
motion.
going to address the alleged errors and things that happened during the trial. I believe that's not appropriate for the sentencing. While I do disagree heavily with most of what he said about those issues, I'm not going to address them independently. I do want to address some of the things that the defense said about what knowledge we have of the situation. So the defense kept saying the word independent evidence over and over and over, and that the court should look to the independent evidence of Douglas Benefield's behavior to support some of these downward departure reasons. However, I have arguments about some of those things that the defense said. For instance, the defense wants you to look at Doug Benefield's deposition testimony that was not allowed to come in to the trial. And we all know that there were reasons that was not allowed to come in the trial. It was following the rules of evidence. However, I can represent to the court that at least one of the things that Mr. Taylor said is completely inaccurate, that Doug Benefield, while he admitted to firing the gun, he never said he did it to intimidate her. So I would just ask that we be cautious about what we are presenting as fact when it is not necessarily fact. The defense also said that Doug Benefield violated the South Carolina injunction. That is also one thing that was never established definitively one way or another, whether he violated it. The defense said that Doug Benefield was caught by a neighbor spying into the house. There are differences of opinions as to that, and I think we went through that in trial, that it was just supposition and someone being identified by a voice after the defendant played a voice recording for her. So that's in dispute, whether he was actually there or not. So to take all of these things as factual and allow them to be used in such a way to say that he was a willing participant in this set of behaviors, I would argue is inaccurate. The defense also said that Dr. Quintal said that Doug Benefield was super controlling and an alpha male, but if the court recalls from trial in cross-examination, I asked him, is this opinion based on, at least in part, based on what Ashley Benefield is telling you? And he said yes. So it wasn't that it was his own independent evaluation of Doug Benefield. He was taking what this defendant was saying to him and incorporating that into his opinion. The defense also said that Dr. Ferris said that Doug was a classic abuser. The court, in the state's opinion, correctly ruled that that was inappropriate opinion testimony and was not allowed in front of the jury. And again, there are all kinds of reasons why that's not appropriate evidence to be considered by the jury. And I would say it's inappropriate for the court to consider that as fact in a sentencing. So what we do end up having,
I'm going to say
is
15 years.
Bits and pieces of a rocky marriage that in the state's
What do
argument
we think,
do
Chad?
not rise
I'm going to say
to prior
15.
acts of domestic violence. Doug Benefield had problems. He lost his temper sometimes. So did the defendant. They had arguments. It was a marriage, and that happens in marriage. The victim, was never an abusive husband the way the defense keeps trying to represent. That is a fictitious idea that Ashley Benefield has put forth and guided through this entire process. And Dr. Russell even said today and acknowledged that she knew that Ashley Benefield had been diagnosed with histrionic personality disorder, and that one of the symptoms of histrionic personality disorder is that you tend to exaggerate and blow things out of proportion. And that is the state's entire theory, is that this particular defendant just blows things out of proportion and makes things into something that never existed. So the court should consider that in trying to determine whether this victim somehow played into this whole incident that happened the night of the shooting. One of the other things that I will mention from what the defense was alleging was improper rulings by the court, I do want to say in isolation just this one thing. The DNA report, the defense was saying that it would have shown that Doug Benefield's DNA was on Ashley Benefield's arm, and I believe that's a false statement. It would have shown that there was some DNA on her that could have been Doug Benefield's DNA, but it also could have been a family member. And the child, that was a toddler at the time, was clearly a family member. So to imply that the DNA report would have clearly shown that Doug Benefield was holding her and at the time that this incident was going on, I believe is not an accurate statement. So as far as the defendant being a willing participant, the victim being a willing participant, we do only have Ashley Benefield's version of events for that night. That's all we have. Yep. And I know the defense in the motion or in the memorandum has mentioned that the court should take what she says as truth, that it's uncontroverted and unimpeached. But I have a case here, Judge, it's Early versus State.
She's got case law, baby.
3, which is a First District Court of Appeal case from 2017. And while this talks about a jury, it does give guidance as to the type of situation that we have here. Even when there is no other witness to the events besides the defendant, a jury is not required to accept the defendant's testimony in support of his self-defense theory as true. Instead, it must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. So,
yeah, did we need a Court of Appeals case to tell us that? Did we need a Court of Appeals case to tell us that? Because I don't think we did. It's like, yeah, even if the defendant is the only witness, because they're the only other one there, the jury can still assess their credibility, which could be informed by other evidence. So the jury is in the position to believe or disbelieve the defendant or any other witness in whole, in part, or any combination thereto. Did we really need a Court of Appeals case to tell us that? Apparently we did. Apparently we did. Unsurprising news is unsurprising.
Believe that the court can wholeheartedly believe what Ashley Benefield said on the stand, or the court is allowed to disbelieve everything she said on the stand. And
right.
if
correct.
that is the basis for this downward departure request, that he was a willing participant or an instigator.
I'm not, Jen, I'm not
entire-
trying to go to other streams to cause trouble. I spent quite a bit of time addressing this already, Jen, but I did not go to other streams to try to cause trouble. And when it was clear that I was causing trouble, I left. That was not my objective. I like Melanie Little. I wasn't trying to cause trouble. I hope we can be friends. We obviously don't see eye to eye on this case, but that's okay. We don't have to see eye to eye. I wasn't trying to cause trouble. I was trying to express my opinion, which obviously is the minority opinion, but I wasn't trying to cause trouble. And I kind of feel bad about the whole thing, to be honest, because I'm upset that I might have made Melanie's life a little bit more difficult in a way that was not intentional. You know, so I kind of feel bad about it. I definitely didn't go into her chat today with the intention of trying to cause trouble. That was not what I was trying to do. I was kind of trying to do the exact opposite, to be honest. Didn't pan out that way, but yeah. Oh well.
Evidence that we have of that comes from Ashley Benefield herself. And the state argues that her credibility is below, much below where it should be, and that it is obvious this was a pattern of behavior, that she had a goal to raise this child by herself and to get Doug Benefield out of their lives. And this was the culmination of that pattern.
Well, I'll stand by my opinion. And like what the prosecution just said is basically correct, right? It's like, this is fundamentally, at the end of the day, this is a one witness case. We have no video, we have no recorded audio, we have only Ashley to tell us what happened in that room or that house that day. Like, up to the day in question, maybe there's other evidence that might provide us some indicia, and that indicia might suggest what happened on the day. But ultimately, in the end of the day, this is a one witness case. And so it's like, do you believe Ashley or do you not believe Ashley? It's like, well, I don't believe her. I don't believe her. And so, you know, that's kind of that conclusion.
And so her credibility is lower than it should be. The other downward departure reasons that the defense mentioned, the one was the PTSD. But if the court looks at that downward departure reason, it says that that the defendant has a mental disability or problem that requires specialized treatment. And the defense has put on nothing to say that she needs specialized treatment for this, even if the court accepts that she does have PTSD. So the defense has not satisfied their burden for that. As far as isolated,
yeah, it is her house.
It's
her house, and if she feels like I'm causing problems,
isolated incident for which the defendant has shown remorse, I would argue that does not apply. Obviously, this was not a one-time thing. This was a pattern of conduct over a very long period of time. Additionally, it's not unsophisticated. It's a culmination of a pattern. And if the court looks at the facts that came out in trial, that there were multiple firearms placed around the house, the daughter and mother were out of the house conveniently at the time when all of this happened.
And she could be right, of course.
This defendant is the only one still alive that has.
I mean, it's a judgment call, right? I mean, it's a judgment call. It's like, I can't really point to anything that be like, this is it or this is not it. It's a judgment call. It's like, it really comes down to, do you believe Ashley or not? How do you assess her credibility? How do you assess what she's saying? The bullet in the back didn't help, I have to say. That certainly didn't help. If we're going to look for an objective piece of evidence, the bullet in the back didn't help. And Melanie, or apologize, not Melanie, that was a mistake. Ashley said it was because he was lunging at her. That's why the bullet wound up in the back. I'm like, I don't know, man. Yeah.
She's trying to say is the correct version of events. So I would argue that that downward departure reason does not apply, or the defense has not met their burden. And Judge, I think it's very difficult.
Ashley could be telling the truth.
This entire trial has been about pretty much demonizing Doug Benefield and making this defendant the victim, when in fact It was
not
the
impossible.
opposite. Doug Benefield did nothing but try to love this woman and try to love this child and try to do the best by them. And at every turn, she abused
Also,
him,
the
in my
compromise
opinion.
verdict is a
She
little
tried
bit
with-
weird. That's one reason to criticize the jury. So if you want like a purely objective reason to criticize the jury, the fact that they came up with this compromise verdict is kind of BS, because it's kind of self-defense or it's not. Right? It's kind of self-defense or it's not. So this compromise verdict of how about manslaughter is kind of bullshit. It should have been murder. It's like, but the jury lands somewhere in the middle, which is kind of infuriating. So that's a reason to be angry at the jury. They should have convicted her of murder or let her go. The compromise verdict is a little bit
Told this child, she tried to get him in trouble at every turn. She tried to do everything to undermine any relationship that they would have. And he continued to go back, which was probably his one fault, was that he continued to go back and he continued to
I don't know if
think
it was
that he could
strictly
make this work.
premeditated.
And this defendant took advantage
But
of that. And then when she
it was intentional.
can't get relief from anywhere else, shoots and kills him. And she got exactly what she wanted for a time. And for that, Judge, we would ask that you sentence her to the maximum 30 years.
Thank you. Rebuttal.
I'm good.
All right. Okay, so at this point, I've heard all the evidence, I've heard the arguments of counsel.
All right, slow this down.
Ms. Benefield, this is addressed to you. Please feel free to consult with your attorneys before you answer, or if you want to answer. But at this point, I always just check with the defendant and say, okay, I've heard, of course, there was a stack of
He's
letters
going to give
that I
her the
got
explicit
from,
chance to allocute, which
your
he
attorney
really
as part
should
of
do
the
that.
Downward departure.
So thank you.
Heard Dr. Russell's testimony today, of course, presided over the entire trial, heard the statements from the state as well. I always ask, though, is there anybody that I haven't heard from, any testimony I didn't hear, any evidence that I didn't hear, anything at all that I need to know to make a fair decision in this matter?
Your Honor, Ms. Benefield feels that I've spoken for her.
Excellent, all right.
Fair
I
enough,
also
great.
give a final statement, and I'm sure that you and your attorneys have talked about this at length. You are absolutely not required to make any statement. However, I also, whenever I have a trial case, we're doing sentencing, if it's an open plea, I do always give the defendant the last opportunity if there's any statements that you want to make. You're absolutely not required to. I'm sure you've already talked to your attorneys about it. But if there's any statement you want to make, please feel free to do so. If not, we'll just move on with sentencing.
I know the court won't interpret her.
Yeah, thank you for giving the explicit chance to allocute.
Fair
Thank
enough.
you for saving me that
And
appellate
as I said,
issue.
you're not required to at all.
Thank you for saving me that appellate issue, Your
All
Honor.
right, is there any legal
Jesus.
reason why sentence cannot be imposed?
No, sir.
All right, so the first thing we need to do is talk about the bases that have been argued for downward departure. And I think today is,
No, the judge is not biased for
It's
those
an
questions.
absolute
Those were really
tragedy
good
that
questions.
we're even here
Those were
today.
legally required
and I
questions.
often,
Thank
in
God
these
the judge asked those
situations,
questions.
sit back and wonder, how did we get here?
Thank God.
How did life bring us to this point, not only here in
We'll see if the
court,
judge is biased. We'll see how it
but
goes.
between the Benefield.
But not for that.
I think both sides have acknowledged, because both the defense, Mr. Taylor, and the state talked about lenses and perspectives. And I think this is a good example of exactly that, where whatever lens you view this case from can really affect how you view the players, the results,
Yep.
the participants,
Very fair.
and the outcome.
Yep. That's very, that much is clearly true,
We've
Your
got
Honor.
the score sheet to start from.
Yeah, given that
The
there's a
issue
minor
is whether a
lawsuit
downward departure,
civil war going,
has
apparently.
been sufficiently, the burden of proving that has been sufficiently met, and then whether the court would grant a downward departure. So the bases are, and I'm going to just take them in alphabetical order from the statute, 921.0026 subsection 2. The first one is D. The defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, or for a physical disability, and the defendant is amenable to treatment. In that particular one, there was the testimony by Dr. Russell that she has diagnosed the defendant with PTSD. It's a complex trauma. She explained the genesis of it and how she reached that conclusion. But importantly, what needs to flow from that is a description of what that specialized treatment is, what sort of treatment is important or would be necessary to treat that PTSD, inpatient, outpatient, what kind of mental health therapies, and so forth. So based upon the competent and substantial evidence that has been presented, I do not find that D has been proven by preponderance of the evidence, all the elements of D. F, the victim was an initiator, willing participant, aggressor, or provoker of the incident. The reason I asked that question and I was looking around is I had a case and I thought I put it in my packet for today, but I'm not seeing it. There was actually a decision in the Florida Law Weekly within the past couple of months, it hasn't been too long ago, where that very issue was discussed. And the DCA in that case actually came down and said, when it talks about the incident, the evidence must support that the victim was an initiator, willing participant, aggressor, or provoker of the incident. And specifically said the court should not consider all of the pre-existing or attendant circumstances and just look at that incident. I think both sides took a great amount of time throughout this case to talk about incidents and events and happenings that occurred before September 27th of 2020. Do I have the date right? September 27th of 2020? But I think the case law talks about that particular day or that particular event. And it doesn't need to be, for this downward departure basis, the law is very clear. The defense doesn't have to prove it by clear and convincing evidence beyond a reasonable doubt. They don't have to prove or provide evidence that is beyond a reasonable doubt. The question is there competent and substantial evidence that in the incident itself, the victim was an initiator, willing participant, aggressor, or provoker of the incident? And quite frankly, the evidence, the preponderance of the evidence has established that Ms. Benefield's testimony is sufficient in and of itself, and I understand the state is arguing that to discount her credibility, but is there evidence in the record that proves by a preponderance that Doug Benefield was an initiator, willing participant, aggressor, or provoker of the incident? And there is. That was the entire basis of the self-defense argument. So I do find that the requirements of F have been met. G, the defendant acted under extreme duress.
It feels like an appeal for the defense, because how can it simultaneously be the defense proves by a preponderance of the evidence that Doug Benefield is an initiator of the incident and she's guilty beyond a reasonable doubt? I guess it depends a little bit on how you parse exactly the incident, but it feels like, how can the defense have proven it beyond, how can the defense have proven he's a provoker by preponderance and she be guilty beyond a reasonable doubt at the same time? That's if it is possible, that feels like it's slicing it thin, man. I don't know. That's tough. If by like initiator of the incident we just mean initiator of like conflict in a looser sense, then maybe, but still, even then, under self-defense law, I don't know, man. The willing participant part, yeah, I don't know. That's okay.
Or under the domination of another person. This is why I was asking about the case law, because I have not seen this particular
And also, of course, it
statutory
depends on you finding her
basis
credible.
applied in.
So I suppose the judge implicitly finds her credible. Because if you don't find her credible, it's a very weird thing, because like her credibility is directly influenced by the jury's verdict, right? Because normally, especially from an appellate posture, we would interpret everything in favor of the verdict. So if she's credible, then the jury finding proof beyond a reasonable doubt to convict her seems problematic at best. And the judge just basically said, well, I find her credible. Feels like there's an appeal in there.
This particular factual scenario where it's argued that the defendant acted under the extreme duress of the victim as a self-defense matter. But just because I haven't seen the case law doesn't mean that it doesn't exist and it can't be argued for those or that purpose. So for the purposes of today, using a similar analysis as I did under F, but also considering the past relationship between the parties, I think there has been competent, substantial evidence to establish by a preponderance that the defendant acted under extreme duress. The domination of another person, I just don't think fits. So to the extent that that particular downward departure basis requires that the duress come from a conspirator, a co-conspirator, a confederate, or a principal, I could be wrong, but I think it applies, and I'm applying it here. Or I think it's been proven. And then J was the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. The case that I talked about a few minutes ago regarding victim was an initiator, willing participant, aggressor, or provoker of the incident, J has similar language. The offense was committed in a sophisticated manner. So I understand the state's argument saying, hey, this was a whole series of events and was very sophisticated in its planning and execution. At the end of the day, the statute itself says the offense was committed in an unsophisticated manner, isolated incident for which the defendant has shown remorse. So if I look at just the incident itself, there's nothing sophisticated necessarily about self-defense and using self-defense. Isolated incident, the defense has pointed out, and the score sheet shows
using self-defense. Wait a second.
There's no prior convictions. The case law requires, though, that all three elements of this be established. The final one is the defendant has shown remorse. Obviously, she's exercised a very, very fundamental constitutional right by not making a statement today. But I can also, I believe, consider the testimony that was provided during the trial. And remorse is not necessarily and doesn't have to be, I'm sorry I did this. Because someone is perfectly entitled to maintain their innocence even in light of a verdict of guilty by a jury. So I find that during the trial itself that Ms. Benefield did demonstrate remorse for this entire incident happening and the culmination and the resulting death of Mr. Benefield. So I do find that Jay has been established.
The state could theoretically appeal.
The non-statutory bases,
the state's going to
explicitly
the state could theoretically appeal, yes.
But I'm going to make a ruling on the individual and culmination of errors for appellate purposes. Again, I'm not aware of any case law that establishes that. To the extent that there's an argument to be made that, and when I say individual errors, I'm talking about fundamental error, right? Because that could just be one thing and fundamentally vitiates the fairness of the entire trial. So individual or cumulative errors being the bases of a downward departure, I'm going to go ahead and make the finding that those are not,
Yeah.
errors by the trial court are not bases for a downward departure.
Yeah, that would be really,
Non-statutory
really,
bases.
really weird if they
I may
were.
be
That doesn't
wrong.
make sense to
We'll
me
find
either.
out.
That'd be really weird if they were.
The second part of the analysis is whether the court is going to exercise its discretion to depart. And that's where you really take into consideration those factors in determining, in light of all of the facts and evidence that have been presented, if this is a case that the court believes a downward departure should be granted. And as I said, I understand completely that two sides of this room are viewing this same case through very different lenses.
That much is readily apparent.
As I consider all of the evidence that I talked about earlier that I reviewed in preparing for today, the jury's verdict, which they did not find Ms. Benefield guilty of the charged offense. It was a lesser included offense that did not include depraved mind. It included doing an act which resulted in the death of another person. I consider the score sheet and what Florida statute or chapter 921 discusses regarding the aim of sentencing, that being the primary purpose of sentencing is to punish, the secondary purpose is to rehabilitate. The PSI, which has been reviewed and considered, and I understand throughout the arguments that the defense has raised their disagreements. For what it's worth, the PSI in the factual part really just recreates or retypes the complaint affidavit. I don't really put a lot of weight on that. I don't need that because I presided over the entire trial. So I don't put a lot of weight on the factual recitation that was in the PSI.
Fair.
And as we all know, the PSI is not controlling on the court.
Also
The
fair.
probation officer who does the report makes a recommendation, but unlike in juvenile court, where the Department of Juvenile Justice's recommendation is somewhat binding on the court, the DOC recommendation is not, but I did review that. And of course, as I said, I reviewed the defendant's sentencing memorandum, all of the various attachments, and listened to the statements that were made today from Dr. Russell, as well as David, Wes, Tommy, and Eva Benefield. And all I can say is thank you to everyone who took the time to write a letter and share your experiences. A number of them talked about growing up with Ms. Benefield, their interactions with her as they've grown up and growing into adulthood. Thank you for the statements regarding your relationships with Douglas Benefield and how his loss has impacted each of you. So when I look at the bases for the downward departure and I consider all of the facts and evidence that have been presented to me, my ultimate conclusion, Ms. Benefield, is that this is not a downward departure case. So with that said,
that makes sense. That makes sense. Like downward departure case really, at least to me, it's hard to really quantify what it looks like, but I'll give you an example. Like the father who kills the murderer of their child, like would be like a downward departure case, right? Because although the father doesn't have the right to kill the murderer of their child, the grief is much more understandable. So like, or the almost righteousness of the motive, right, would be like an example. So yeah, it makes sense this isn't a downward departure case. I still think we're looking at probably lower than not. So I think we're looking at like the 10 to 15 year range. This doesn't feel like a max case. It feels like the judge is going on the lower end of the scale. Feels like 10 to 15 is kind of where this is going. So we'll see.
The sentence of the court will
I
be
guess
as
we're going to find out
follows.
right now.
I'm going to sentence you to 20 years in
Okay.
Florida State Prison.
All right.
That's to be followed by 10 years of probation.
I'm a little
Upon
surprised.
your release, and the Florida State Prison was, of course, with all credit for time served. You must
I'm a little
initially report to
surprised.
the Bradenton Department of Corrections.
20 years is a
We'll
fairly,
provide you a map of where that is.
more than half. Where I
Cost
guess
of supervision will be a
kind of
condition
exactly half,
of
to be honest.
supervision. Based upon the testimony
Right in the middle.
of Dr. Russell today regarding you suffering from and being diagnosed
Yeah, that's
with
reasonable.
PTSD, the court is going to order as a condition of your probation that you obtain a mental health evaluation at your expense within 60 days of beginning your probation. You're to complete any recommended treatment, including residential treatment and aftercare if it's recommended, on the first attempt at your expense. You're to provide proof to your probation officer regarding the evaluation, participation in, and completion of that treatment. If it's necessary for your probation officer, you'll need to sign any waivers or releases that are necessary for them to get the information that they need or speak with your evaluators and treaters.
Does
I
Jules
am
have a
going to order
badge
the
on?
forfeiture of the firearm in this matter, that being the Springfield
She does.
45. And I'm ordering that you have given up all rights, title, and interest to the same. I haven't heard anything about restitution at this point. I am going to order restitution. I'll reserve jurisdiction to determine the amount of restitution, the payee or payees, the payment schedule, if any, and other terms and conditions of restitution. I'm also going to reserve jurisdiction on the restitution to determine whether or not to waive or reduce the monthly cost of supervision and/or the fees and surcharges that are associated. I'm going to impose the following monetary obligations: the felony adjudication of guilt court costs, $100 cost of prosecution.
200.
Do you have an affidavit?
I don't have it with me.
You got to love these random court costs. In
It's
addition to the
required by
20 years,
Florida law.
you owe us $100. You just got to smile, man. Who comes up with this?
If you want to
3,000
continue on,
page.
we'll try and find it.
All right. If an affidavit is for cost of investigation is presented, I'll order $200 to the Marietta County
Oh,
Sheriff's Office.
$200. That's getting really expensive now.
For now, I'm going to make all the legal financial obligations a condition of probation. All right, State, now that you've seen where I'm at with the sentencing, was there anything that you want to do, any further arguments, anything else you want me to consider?
Judge, my only concern would be the mental health evaluation. I would prefer that it not be with Barbara Russell when she's on probation and has to do the mental evaluation.
You don't want what?
You have ordered that the defendant do a mental health evaluation when she gets out on
Correct.
probation, and I would request that it be someone other than any of the doctors that were involved in this case. So not Barbara Russell or Dr. Quintal or Dr. Broder. Those-
Okay. I'm not going to order that. I'll let you pick your mental health professional that you want to see and consult with. Sir, now that I've told you where I'm at, was there anything that I need to explain or clarify?
No, sir. If you would, how long is the period of probation?
It was 10 years.
Yeah, 10 years
Okay,
probation.
Ms. Benefield, you have 30 days to appeal the judgment and sentence of, oh, yes, sir.
Make one statement for the record. I object for the record and argue it's an abuse of discretion based on the undisputed facts not to grant a downward departure.
Oh, yes, sir, absolutely. I think that's generally preserved no matter what, but
I do too, but.
I appreciate your belt.
But the appellate courts like to find.
You
out.
always want to preserve that. You just want to make your
I understood.
objection.
Belt
I
and
appreciate
suspenders, No
that.
problem at all. Yes, sir. So objection to the abuse of discretion for not granting the downward departure. Noted. All right, Ms. Benefield, you have 30 days to appeal the
Good
judgment.
luck
and
on that
sentence of
on
the court. If you
appeal.
can't afford to hire a lawyer, one will be appointed to represent you. Go ahead.
Sorry, I'll just have one.
Abuse of
one-
discretion appeals
Is it
are really
regarding
hard. Legal errors are easier. Abuse of
Appeal?
discretion is hard.
Oh, well, go ahead then.
And then, even then, legal errors are like still you have to find a legal error that matters because you still have harmless error.
Manatee County.
But, you know,
for at least
appeals are for losers for a reason, man.
not 30, so that we can tie up all the loose ends in preparation for the appeal.
If it's abuse of discretion, you're going to have a real tough time.
I don't know how much pull I have over that. DOC comes gets people when they come get them.
Can I suggest that Your Honor set this for a report in perhaps 30 days?
All right, why don't you send me an order directing the sheriff to hold her pending any final hearings or matters? And I'll,
Judge, the most specific thing, we're going to be filing a motion for bond pending appeal, so that's why we're.
keep her there for that.
Yes, so to avoid the necessity of her going back and forth.
Absolutely. So do me a favor, contact Kelly, my JA, get that set. I didn't see it's been filed yet, but get it filed.
It has not, but I will file it tomorrow.
All right, get it filed. Talk with Kelly about getting a hearing date, and then I'll sign an order to hold her until after that date. Absolutely.
Thank you, Judge.
Thanks.
Of course. Okay, for the appellate purposes, what I was going to say is, ma'am, speak with your attorney. You can hire someone if you want, a private attorney for that. If ultimately you are going to seek the services of the public defender, I'll just need a financial affidavit and a motion to appoint. And then once Mr. Taylor completes all of his obligations as trial counsel, we'll get a local PD appointed and then the 10th Circuit PD. All right, ma'am. Thank you very much.
All right, fair enough. Okay. Well, given the jury's decision to somewhat split the baby on the issue, I think 20 years as a result seems like a reasonably fair sentence. I mean, the range was 10 to 30, and there were factors that seemed to suggest against a maxed out sentence. This seems to be a relationship that, doesn't necessarily cry for the max, unlike Sarah Boone. So, 20 years seems like a reasonable sentence. I'm actually somewhat surprised the judge didn't go for less, to be honest. It sounded like, while he wasn't going to grant the downward departure, he was still going to use those factors. And maybe to some degree he did, but I thought he'd go further and it'd be more like 10 or 15. But 20 years with 10 years probation to follow. Yeah. So interesting, to be sure. But yeah, I have no problem with the sentence, given the jury's decision to, again, split it. The jury's decision to split it is odd, but of course legally supportable. Because, well, I think she's guilty of murder, so I necessarily think she's guilty of manslaughter, because it's a lesser included. So, therefore, the jury is allowed, or at least they have the power to show mercy during nullification, right? They have the power, but not the right. So you could even go that far if you wanted to and say that they nullified murder, which is their prerogative. If they believe, so you could even go that far. In terms of appeals, it sounds like she's got some reasonable appeals, although it sounds like, based on the defense's description of it, it sounds like abuse of discretion stuff, which is going to be tricky because judges get pretty wide discretion in controlling the courtroom and controlling who testifies and controlling when and controlling the scope and controlling timing and controlling a whole bunch of things and making decisions based on evidence. It's literally what judges do about like it being sufficiently reliable and being too prejudicial and every other rule you've ever heard of in your life, right? Judges judge. And the issue isn't whether another judge would have made a different call, because judges will disagree with each other all the time, right? There is an inevitable human factor in this thing. So the issue isn't, whether another judge would have made a different decision, but whether, one, it's legally wrong, clear error, or two, it's so outside the bounds that it seems completely unfair. And, that's difficult. That's really, really difficult. But given what the defense put on the record in what sounded suspiciously like a motion for a new trial, to be quite honest, but what the defense put on the record, it sounds like they think at least they have some ideas about evidence that should have been brought to the jury that was improperly excluded. Now, I think that the defense somewhat mischaracterizes some of that evidence, but again, that's what they do. And so, they can try to appeal. and see, and it will be interesting. And if, when the briefs start coming down, I think I might read these briefs. So chat, take note. If you happen to see the appellate briefs for this case, hit the webs, let me know and we'll read the appellate briefs, because I'd love to read it and see whether or not the defense's reasoning, once you really put it in writing and once you really, work through the analysis, whether or not the defense might have something. Because, we always want to make sure that we get the legally correct result. And we always want to make sure that the jury is basing their decision based on legally cognizable and legally correct evidence. And so if there's something there that, requires an appeal or requires a reversal for a new trial, then, that'd be cool. And, we can try to assess it from there. But very, very interesting. What was the upcoming hearing? I didn't quite understand what the upcoming hearing was. I didn't know if that was a new hearing for a new trial. I didn't know if that was hearing relating to the restitution that's going to be ordered. Yeah. So yeah, I'm not sure. I'm sure, yeah. The judge also seemed to provide grounds of appeal in his own statement, because he's like, I think the defense proved that he was the initiator by preponderance. And it's like, well, if you think that he's the initiator by preponderance, then I'm not sure how she's also guilty beyond a reasonable doubt at the same time. So there's definitely grounds for appeal. I can't speak to, ultimately the ultimate soundness of the appeal, but it sounds like the defense had something to work with. You'd love to see me read appellate briefs on cases. It's a side we rarely see. I read appellate briefs all the time. That's how my channel really started, was with appellate briefs and appeals. We've gone a little bit more into trials lately, but I read appellate briefs all the time. Appellate briefs kick ass. Appellate briefs is where I live. Appellate briefs is how I think. Appellate briefs is where I live. Trials are messy and confusing and involve facts and emotions and feelings. Appeals are more legally pure. Are we doing Supreme Court oral arguments? Yeah, you better believe it. In fact, we got one coming up pretty soon. In fact, I think we've got, let's see, when is it supposed to happen? I think it's the 7th. But let's take a look at the calendar so I can double check. Let's see. Let's take a look at the calendar, see what's happening today. Let's take a look at the calendar, see what's happening in every way. Let's see. It's on the 4th, so it's tomorrow. So we're doing oral arguments pretty soon. Probably not tomorrow, because I usually like to wait for the transcript to be synced with OYE, and that usually takes a day or two. But tomorrow is a controversial case at the United States Supreme Court. United States versus Scrimetti. The issue: whether Tennessee Senate Bill 1, which prohibits all medical treatments intended to allow a minor to identify with or live as a purported identity inconsistent with the minor's sex, or treat purported discomfort or distress from discordance between the minor's sex and asserted identity, violates the Equal Protection Clause. In other words, is banning trans care for the kids legal or not? That should be pretty spicy. So we will wait for the transcript so that we can do the OYE thing. There's a press conference. Do you want to watch the press conference? What time will I be on? I don't know. It usually depends when OYE does its thing. Usually it takes OYE a day or two. It's up to OYE. OYE is a private site, and it does the synchronization between the transcript and the audio, which makes it much easier to follow. So I usually wait for the transcript to be sent. It usually takes a day or two. It depends when oye's. So I don't know for sure. So that should be exciting tomorrow. Let's see if there's anything that's been good recently we could do an oral argument to. Maybe we could do an oral argument later today. Let's see if there's been anything good recently. Mm-hmm. We did the weapons part kit, so we did that in October. Was there anything in November? Nope. So we did and that's the beginning of the term. So far we've had the Ghost Guns case, Vanderstook, and then there is whether the exhaustion of state administrative remedies is required under 1983, which is pretty geeky, and there's a lot of really niche stuff. Did we do Glossop? We did do Glossop. We did oral argument in Glossop. That was a pretty good case. Dealing with Brady disclosures, that was a fun case we did. So we already did that. We could do the veteran one, whether the U.S. Court of Appeals for Veteran Claims must ensure the benefit of the doubt rule was properly applied during the claims process in order to satisfy the statute, which directs court to take due account of the Department of Veterans Affairs application of the rule. So Veterans Affairs is required to give the benefit of the doubt to the veterans. Does court have to ensure that? I would think so. Let me answer this real fast. Hey, Nate, I'm streaming. What's up? All right, thanks, man. All right, so yeah. This seems delegati, whether a crime that requires proof of bodily injury or death, but can be committed by failing to take action, has an element of use, attempted use, or threatened use of force. I would think no, but, apparently someone raises that question. So there's a lot of like really niche, geeky shit so far this term in the Supreme Court. Not a lot of really sexy stuff so far at the Supreme Court. A lot of really niche shit, but nothing really super sexy. The trans issue is by far and away the sexiest one. Well, at least, Am I on Facebook? Yes, I do have a Facebook account. Yeah, we have Facebook. Yeah. So, I'm okay with the result. I'm okay with the result in the Ashley case. I have no problem with it. Given the posture the jury left us in, and given the relevant things the judges to consider, and given the factors that were presented, and given the fact that Ashley seems to have been a victim of some sort of domestic violence, including tracking and some other behavior that seems questionable at best, then I think 20 years sounds like a pretty appropriate sentence. So I have no problem with that. I have no problem with the 20-year sentence. The appeals, though, should be pretty interesting. So I look forward to reading the briefs and seeing whether or not the judge, and therefore implicitly myself, got it wrong. I'm going to go to the gym. I'm going to try to do 20 minutes on the elliptical today. I did 15 minutes yesterday. I'm going to try for 20 today. I'm going to try to do 20, and then I'm going to have some chili. And I'm pretty excited about those things in my life. So I think I'm going to go ahead and sign off. And I don't know what else we're going to. Oh, I guess today we could also do the sentencing in the South Carolina golf cart DUI thing. We could do that today, potentially. So we might be on later for that, because I'm a South Carolina boy and, might want to check that out. And we'll see. All right. I've been on Civil Law. Until later, my friends. I hope all is well. Cheers for now, my friends. Have a great one, and goodbye.